Thank you. Be seated, please. All right. Remind everybody to make sure your cell phones are off. All right. Now, ladies and gentlemen, jury service may be strange to some of you, so a short explanation is ordered before we commence the trial. Those who participate in a trial must do so in accordance with established rules. It's true of the witnesses, lawyers, the judge, and jurors. Lawyers will present the evidence according to the rules. The judge is the one who enforces those rules and determines what evidence may be admitted. Now, as a jury, you will be the sole judges of the facts, credibility of the witnesses, and the weight to be given to their testimony. And at the end of the case, the court will instruct you regarding that law, and you'll apply that to the facts. It is your sworn duty to accept the law as it is given to you by the court. Now, the procedure for the trial will be as follows. First, the attorneys are going to outline what they think the evidence is going to be. These are called opening statements. They are not evidence, but are simply a preview of the claims that each party believes will develop in the case that are designed to help you follow the evidence as it is presented. After that, the state will present its evidence, and then after the state rests, the defendant may, but is not required, to offer evidence. If the defendant should present evidence, the state may, but is not required, to present rebuttal evidence. After the conclusion of all the evidence, the court will instruct you on the substantive law regarding the issues in the trial. You'll then hear closing arguments from the attorneys, and then at the conclusion of that, the court will instruct you on the methods of deliberation and how to return and report a verdict. Now, the procedure for questioning of witnesses is as follows. The party that calls a witness asks questions first, and that's referred to as direct examination. After the conclusion of the direct examination, the opposing party may ask questions. That's called cross-examination. And upon completion of the cross-examination, then the party that called the witness may, but not required, to ask additional questions regarding those matters that were testified to on cross. That's called redirect examination. Jurors are not permitted to ask questions. Now, during the trial, it's likely attorneys will make objections. An objection is the procedure by which the attorneys raise a legal issue that must be decided by the court. I don't make those things up. I don't just decide what I think is fair. I am required to follow the rules prescribed by the Supreme Court and statutes adopted by the state of Ohio, and those are the basis for my rulings. If I say that the objection is sustained, that means that I've determined that the question and or the answer are not permissible. And then that evidence will not be permitted to be brought before you. If I say overruled, then I've determined the question and the answer are both proper. Now, occasionally, when people talking quickly to each other, an answer may be given to a question while an attorney is making an objection or before they can get the objection out. And after I consider the matter, the objection, if I determine that the question or the answer or both were not proper, then I will say that either strike that testimony be stricken or that you'll be required to disregard it. And that'll also be in the closing instructions. And then what that means is that you're not permitted to consider it. Now, you're not computers where you can just hit delete and it's off your screen. You may remember it when you're deliberating, but the key is if somebody says, well, what about that? Say, well, that was stricken and we're told to disregard it. So, it may be hard to forget, but you're not allowed to consider it. That's what that means. Now, it's important for you to be fair and attentive through the trial, but during the trial, you're not to discuss the matter in any way with anyone. And so if you are a person who texts or whatever Twitter's called now, X, or any other kind of social media, you can tell I don't, then you're not to do that during the trial. Now, you may use those social media, post about other things, but not about the trial. Don't even say you're on jury duty. Just don't do anything or say anything about the case. Do not read anything on social media or any postings that may be about the trial. You're not to permit anyone to discuss it with you or in your presence. That includes during the breaks that you have for lunch or recesses if you make any phone calls. You're not to form or express any opinion on the case until it's finally submitted to you. Now, obviously, as humans, we have first impressions when somebody says something. But, you set that aside because you're not to come up with an opinion on the matter until the case is completed. Because until you have all of the evidence, you have the instructions of the court, and you've heard the arguments of the attorneys, you don't have everything that's necessary to make an opinion or decide the case. So don't express any opinions during the pendency of the case. Now, it's easy to understand that you can't discuss it with others, but it may be a little more difficult to understand why, and I'll explain to you why you cannot discuss the matter among yourselves during your breaks. Because again, as I just said, until the case is complete, you've had everything, all of the evidence and the instructions and considered the arguments. You don't have everything that's needed to make a decision. And you have to discuss this as a group. The 12 jurors who will deliberate are the ones who will deliberate and form the opinions and make the findings that are required. And so if 2 or 3 of you are talking outside, if you were talking outside and you discussed the case, or several of you were accumulated in the jury room and you talked about the matter, you know, you're not, all 12 of you are not considering it. Plus, again, the case isn't complete and you don't know everything that's going to come out. Because I can tell you from experience in life, as well as particularly in the law, is when something starts out, it may seem to be one thing and ends up being something completely different. It may be what it started out to be, it may be slightly different, and it may be totally different. So you just need to keep an open mind and be patient and wait until the case is concluded. You're also to explain this rule again to your family or friends or anybody you may meet during the breaks. If they say, oh, okay, what's the case about, or whatever, you have to explain to them, I can't discuss it. People might say, well, I served on jury duty and I was allowed to talk about it, but they've forgotten not until the case was over. Once the case is over, you may discuss it with anyone you choose, or you don't have to discuss it, but you may. It'll be your decision at that time. Again, you're not to talk with the attorneys, parties, witnesses during the trial, and they're not to talk with you. I mean, I understand it's polite to say, excuse me, or hello, or something like that, but other than that, no discussion, because somebody might think, well, you know, there's been something improper that's happened, and so we just want to avoid that. Now, if at any time, well, let me back up. You're instructed that you're not to read, view, or listen to anything or any report about this matter in newspaper, radio, TV. Don't think we'll make those. Social media, internet postings. Nothing about this case. If you see something about the case, do not read it. Don't permit anyone else to read it to you, nor to comment about those matters they may read while they're in your presence. And again, the reason for that, if we have people posting, whether it be reporters or just people that are sitting in as spectators and then go and post on social media, again, they're there to report or comment on their impressions. That is not, they're not under the obligation that you are, they're not under the oath that you are to follow the law and apply it and make a decision according to the law. You're not to investigate or attempt to obtain any kind of information on this case outside the courtroom. It's highly improper for you to do that. You heard the comment or the question about the Whitmer trial and experiment, but it also applies to other things. Like, for instance, if you hear about a matter that you're not familiar with, or you think, I think I've heard something about that, or I think that it's not what I understood, you can't go on the internet and look it up and research it yourself. That's outside the record. Once the case is over, you may do that, but not during the case. Now, if by chance, doesn't happen very often, but occasionally it does, but something happens where you end up talking with somebody, or they say something about the case, or you find out something during the testimony that affects, maybe related to what the voir dire questions were that you didn't realize it until you saw the face of the person or you heard the testimony. Bring it to the attention of the bailiff immediately, and then he will bring it to me. I'll consult the attorneys and make the decision what has to happen. Now, once in a while, if something like, I've had cases where people went to lunch and somebody said something about the case. If that happens, report it, and then we may need to question you about it just to determine if it's had any impact on the case and your ability to serve. One thing that I don't want you to do is come back and while you're back in the jury room and other people are coming in, say, this happened at lunchtime, do you think I should report it? And the reason I'll tell you this is about 30 years ago when I was prosecutor, we were in a 5-day trial and we had 12 jurors and 3 alternates. And that happened at lunch. And the guy came back and instead of reporting to the court, he brought it up in the jury room, so all 15 jurors heard it. So we spent that afternoon questioning 15 jurors about what that comment was, what the other jurors said to them, and whether or not, it had any bearing on the case. So we ended up losing a whole afternoon of trial, asking jurors questions. So again, if you have any doubts about it, go ahead and report it, and then we'll deal with it. But don't say anything to your fellow jurors. Now, since this is a one-day trial, I don't permit note-taking. And when we do have longer trials, I do, and I have instructions on how to handle that. But basically, in a short trial, my concern is that people will start taking notes about things that turn out to be not very important. And I'll give you my own example. Many more years ago than I like to admit, I was an 18-year-old freshman at Ohio State, graduated from Hillsborough and was scared to death. My first class, I started writing down. Everything the professor said, I was writing down. And then at the end of the day, or at the end of the class, when I looked at my notes, I realized a lot of what I wrote down just wasn't important. And I'm thinking, well, I remember he said something else, and I think that was important, but I can't remember what it is. So I was so concentrating on things early on that I kind of lost sight. And so that's the concern that happens, I think, particularly early in trials. And so that's one of the reasons I have special instructions on how to do that. But that's the reason for that. We have a relatively short case here today, and 12 people can collectively, talk about it and refresh each other's memory. Now, from time to time, you will see that we'll have bench conferences. It may be requested by the attorneys. I may request it. They'll come up here like we did when we selected the jury. You'll hear the static, and we'll be discussing matters that you may or may not be permitted to hear. And so because, I mentioned to you earlier, if you hear something that I decide is not admissible, I tell you to disregard it. Sometimes if there's an argument, they want to tell me what they expect the answer is. So I have them come up here and listen to that and then make the decision. Because ultimately, if I decide you can't hear it, then I've saved you something else you have to disregard, trying to keep your job easier rather than making it harder. And then sometimes there's things like logistics, that we need to discuss. Now, again, during all recesses, remember all these instructions. I'll try to remember at each break to say, remember the instructions of the court. That means everything I told you that applies during the case, you're to follow during the breaks. All right, now with that, we're going to go ahead and begin the trial, and it starts with opening statements. And the state, as the plaintiff, goes first. Ms. Collins, on behalf of the state.
May it please the court, Mr. Borger. Ladies and gentlemen of the jury, today the state will present you with the evidence that proves that this man, Stephen Weil, on 3 separate days sold methamphetamine or offered to sell methamphetamine to an undercover citizen working with the Highland County Task Force. Chief Investigator Randy Sanders and Investigator Chris Bowen run the Highland County Task Force, and one of their main jobs is to eradicate Highland County of illegal drugs. In doing that, they often work with citizens who are able and willing to buy drugs off of dealers. 2 of those undercover citizens are Steve and Joy Debo, and one of the people they were able to buy methamphetamine from is Stephen Weil. On December 5th of 22, Joy set up a deal with this defendant using her cell phone, and you will see the pictures from the cell phone detailing how the deal was arranged. During the trial, we're going to refer to this as the cruiser deal. The defendant offered to sell Joy 2 8-balls of meth for $120. Joy was then searched to give and buy money and an audio and a video recorder. She was driven to the gas station in Morristown, where she waited for the defendant to meet her. This defendant walked up to Joy's vehicle, handed her a small bag of a white crystal substance, and she handed him $120. The defendant then walked away from her vehicle. She met up with Investigator Sanders and Bowen, where she turned over the bag of crystal substance and the audio and video recorder. The bag of crystal substance was sent to BCI, where it tested as 6.90 grams of methamphetamine. Also important in this first deal is that the gas station in Morristown is less than 1,000 feet from the high school, so the first deal took place within 1,000 feet of a school zone. On December 8th of 22, Joy set up another deal with the defendant using her cell phone, and again, you will see the pictures of the phone detailing how the deal was arranged. During the trial, we're referring to this deal as the deal when the truck quit working. The defendant again offered to sell Joy 2 balls of meth for $120. Joy was then searched, given buy money, and an audio and video recorder. She was driven to the defendant's house in Danville, where she waited for the defendant to come outside. The defendant walked out to her vehicle, handed her a small bag of a white crystal substance, and she again handed him $120. Stephen Weil then walked away from her vehicle, and she met up with investigators Sanders and Bowen, where she turned over the bag of white crystal substance and the audio and video recorder. The bag of crystal substance was sent to BCI, where it tested as 7.38 grams of methamphetamine. Finally, on December 28th of 22, Joy set up another deal with this defendant, using her cell phone again and again. You will see the pictures of how the deal was arranged. We refer to this as the cigarettes deal. The defendant offered to sell a few grams of meth for $50. Joy was then searched, given buy money and an audio and video recorder. She was driven to the defendant's house in Danville again, where she waited for the defendant to come outside. This defendant walked out to her vehicle, handed her a small bag of a white crystal substance, and she handed him $50. The defendant then walked away from her vehicle. She left and met up with investigator Sanders, where she turned over the methamphetamine and the audio and video recorder. That bag of crystal substance tested as 2.57 grams of methamphetamine. Ladies and gentlemen, I expect these will be the facts of the case and the evidence that will be presented today. You will see audio and video of the deal, pictures from the phone arranging the deal, the bags of methamphetamine, and detailed notes from the deals. You will hear from investigators Sanders and Bowen, who have over 60 years of experience between them, most of it doing undercover drug deals, just like the ones you will hear about today. You will hear from experts from BCI, whose only job is to test and weigh chemical substances or suspected narcotics. Finally, you will hear from Steve and Joy Debo, who will explain how they arranged to purchase meth from this defendant, how they were paid for their work with the task force. And you will hear the testimony. After you hear the testimony and review the evidence, I am confident that you will find this defendant guilty of all counts. Thank you.
Thank you, Mrs. Collins. Mr. Borger, on behalf of the defendant.
Thank you, Your Honor. May it please the court, Your Honor, prosecutors Collins and King. My name is Tyrone Borger. Reintroduce myself to you. Today, what we're going to hear is the great weight of the state coming down on my client, Mr. Weil. You've heard what the prosecutor says that they are going to establish, and they have to establish this beyond a reasonable doubt. This is a very, very heavy burden. There are 3 separate allegations on 3 separate days, and it's important that you understand that those 3 days are not to be taken together. Each one is individual. And so you're going to look at some evidence. Admittedly, there's going to be some video evidence, but I don't believe the video evidence is going to show what the prosecutor says that they are going to prove. And it's going to be up to you to decide. You're going to be taken into a world of confidential informants, where confidential informants are contacting regular people who are addicts, trying to get them set up for big drug charges, trafficking. She talked about 3 separate incidents, and the allegation is that there's a grand total of $270 for all 3 transactions. That's what the allegation is. And for this, the state is trying to have my client be seen as a drug trafficker. I believe the evidence is not going to show that. I put my faith in you. Looking forward to this trial. Thank you very much.
All right, thank you, Mr. Porter. First witness.
Aaron Miller.
That move to separate the witnesses if there's...
You did not, but the court will order that there be a separation of witnesses, so if there are any persons that intend to testify during the trial, they're to be excluded, and I'll leave those up to each party to enforce that. Exception being Mr. Bowen, who's the state's representative. All right, good morning. Have you been sworn in the clerk's office?
Yes, I have.
All right, if you would have a seat over there. First of all, if you have a cell phone, make sure it's off. All right, and just have a seat over here. Now, these proceedings are broadcast on YouTube. Do you care if you're shown or not?
Oh, that's okay.
All right, thank you. Now, yeah, would you slide the mic clear over there as far as it'll go, that being consulted in front of you? It slides to your left.
Oh, it slides to me.
Yeah, the board, yeah, there you go.
Okay.
All right, thank you. All right, you may inquire.
Please state your name for the record.
Aaron Miller.
And Ms. Miller, are you currently employed?
Yes, I am.
Where are you employed?
I am employed at the Ohio Bureau of Criminal Investigation.
What is the Ohio Bureau of Criminal Investigation? What do they do?
It is a state-run agency. It is a part of the Ohio Attorney General's office, and it provides laboratory and investigative services to law enforcement agencies throughout the state of Ohio.
And Ms. Miller, what's your educational background?
I graduated from the Pennsylvania State University with my Bachelor of Science degree in forensic science.
Have you testified in court before?
Yes, I have.
Have you completed testing programs since being employed at BCI?
Yes, I have.
And have you previously been qualified as an expert in substance identification and measurement in other courts in Ohio?
I've been qualified as an expert in the analysis of controlled substances.
At this time, I would ask the court to declare Ms. Miller as an expert in the analysis of controlled substance.
Objection.
I have no objection, Your Honor.
All right, she is so declared. You may proceed.
Ms. Miller, does BCI have a written procedure manual for substance identification and measurement?
Yes, it does.
And when you're testing chemicals, do you follow the lab protocol?
Yes, I do.
And did you follow that lab protocol in this case?
Yes.
Now, when you receive an item into the lab for testing, what steps do you follow?
I do not receive the evidence myself from the agency. However, I can describe the submission policy if that's what you're asking.
Well, how did you get the evidence?
I received the evidence from the secure chemistry drug vault at the laboratory and place it into my custody.
And then you complete testing on that?
Yes, I do.
And what sort of testing is done to determine the identification of a substance?
There are different types of testing that can be done depending on the type of substance that is submitted. In this case specifically for a crystalline type substance, I would perform presumptive chemical testing and confirmatory instrumental analysis.
And is this the method that is approved and accepted by BCI?
Yes, it is.
May I approach the witness?
You may.
Going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize that?
Yes, I do.
And what is that?
This is a copy of the report that I issued in this case.
And did you prepare that report?
Yes, I did.
And is it a report that is generally prepared by whomever's doing the testing at BCI?
Yes, it is.
Now, according to that, when was the evidence received by the lab?
The evidence was received to the laboratory on December 16th of 2022.
I'm next going to hand you what's previously been marked as State's Exhibit 2 for identification purposes. Do you recognize that?
Yes, I do.
And what is that?
This is the evidence that was submitted to the laboratory, and I recognize it based on my initials and date across the seal, as well as the BCI unique case identifier.
Now, once you received that evidence, did you use the previously discussed testing methods to determine what the substance was?
Yes, I did.
And what were the results of your analysis?
I determined that the evidence was found to contain methamphetamine.
And how do you determine you're doing the testing properly?
There are a lot of quality control measures that the laboratory requires in order for evidence to be tested. With each step of the process, there are specific measures that have to be met in order to proceed.
And was the testing in this case performed properly?
Yes, it was.
In your expert opinion, based on your testing, education, and experience, what is the substance contained in State's Exhibit 2?
The substance was found to contain methamphetamine.
Now, did you then weigh the substance?
I weighed the substance prior to any analytical testing that I performed, so prior to removing any evidence.
So when you receive it, it's in a little bag, is that correct?
That is correct.
Do you weigh it in the bag?
I do not.
So do you dump it in something, or explain that?
Yes, I use a piece of weigh paper. It's similar to a piece of parchment paper or wax paper. I place it on my balance and zero it to ensure that no weight is contributing from that piece of weigh paper. And then I place the contents of the evidence bag directly onto that piece of weigh paper and record that weight.
And in your expert opinion, based on your testing, education, and experience, what was the weight of the substance contained in State's Exhibit 2?
The weight was 6.90 grams.
And did you record those findings on the report outlined in State's Exhibit 1?
Yes, I did.
And what did you do with this evidence after you analyzed it?
After I analyzed the evidence, I sealed the evidence, returned it to the same secure drug chemistry vault that I retrieved it from to begin with. I issued a report on my findings where it went for peer review.
No further questions.
Cross?
I have no questions for this witness.
All right, thank you. All right, you may step down. Thank you. I just leave that right there. Thank you. All right, your next witness.
Lauren Goins.
Good morning. Have you been sworn in down this clerk's office?
Yes, I have.
All right. If you have a cell phone, make sure it's off, and just have a seat right over here. We are broadcasting this on YouTube. Do you care if you're shown on the broadcast or not?
No, that's fine.
All right, thank you. If you would slide that mic clear over to your left. It's on that board. All right, thank you. You may inquire.
Please state your name for the record.
Lauren Goins.
And are you currently employed?
I am.
Where are you employed?
I'm employed with the Bureau of Criminal Investigation, commonly referred to as BCI.
And we've just heard what BCI is, so how long have you been employed there?
I've been employed since July of 2017, so just shy of 7 years.
And what's your background in education?
I have a Bachelor of Science in Chemistry with a concentration in Forensic Science from Methodist University in Fayetteville, North Carolina. That was awarded in in December of 2011. And I have a Master's of Chemistry, in Chemistry from Chicago, Illinois Institute of Technology. That was awarded in December of 2000, and that one, was May of 2017.
Have you testified in court before?
I have.
Have you previously been qualified as an expert in substance identification and measurement?
I have been deemed an expert in the field of forensic drug chemistry, which would incorporate the identification of controlled substances and then taking their mass determination.
Have you completed any sort of testing program since being employed at BCI?
I have completed a specialized training program that is held within BCI for our training of the controlled substances and the analysis and identification.
At this time, I would ask the court to declare Lauren Goins an expert in forensic drug chemistry.
Any objection?
I have no objection, Your Honor.
All right, she's so declared. You may proceed.
Does BCI have a written procedural manual for substance identification and measurement?
We do have a methods manual.
And did you follow that method and protocol in this case?
I did.
Now, when you receive an item into the lab for testing, what steps do you follow?
When evidence is received in our London office, it is placed into a drug vault for storage. So when I receive the case for analysis, I will go retrieve it from the drug vault, take it into my custody for that chain of custody, and then I will proceed to analyze it based on a testing schematic that I use.
Now, when it's in this drug vault, is it able to be contaminated by other things in the drug vault?
No, ma'am, it is not.
And why is that? How do you keep it separate?
All of our evidence is contained within a plastic K-pack. It's just a very large plastic container. I shouldn't say very large, relatively larger container that keeps each piece of evidence and each case separated.
Now, what sort of testing do you do to determine the identification of a substance?
Generally, I will do a color testing as well as instrumental analysis for the presence and identification of any substance that may be controlled.
And did you follow those testing procedures in this case?
I did.
I'm going to hand you what's previously been marked as State's Exhibit 21 for identification purposes. Do you recognize that?
I do.
And what is that?
This is a report for BCI lab number 23-10154.
And did you complete that report?
I did.
And did you complete that report as the normal course of business at BCI in relation to this testing?
I did.
I'm next going to hand you what's previously been marked as State's Exhibit 22 for identification purposes. Do you recognize that?
Yes, I do.
And what is that?
This is the K-Pack and container for the item for BCI case number 23-10154.
And how do you recognize it as being that?
I recognize it based on the barcode that is on the evidence, and I recognize it because my initials and date are both on the seal that I have, as well as that barcode that's on the container.
Did you, when you received this into your lab, did you use the previously discussed testing methods to determine the substance contained therein?
I did.
And were you able to determine that your testing was done properly? It's like, are there controls that you do to determine that your testing is being done properly?
Yes, ma'am.
And did you go through those controls in this case?
I did.
In your expert opinion, based on your testing, education, and experience, what was the identity of the substance contained in State's Exhibit 22?
State's Exhibit 22 was found to contain methamphetamine.
And did you then, prior to testing it, did you weigh the substance?
I did.
And you remove it from the bag before you weigh it?
Yes, ma'am. Part of testing is to remove the substance from any packaging.
In your expert opinion, based on your testing, education, and experience, what was the weight of the substance contained in State's Exhibit 22?
State's Exhibit 22 was found to contain 7.38 plus or minus 0.05 grams of methamphetamine.
And what did you do with this after you analyzed it?
After I completed analysis, I sealed all layers of packaging and returned this to a drug vault to be returned to the department.
And did you record your findings from your testing on the report identified as State's Exhibit 21?
Yes, I did.
You can put those up on the bench. I am next going to hand you what's previously been marked as State's Exhibit 46. Do you recognize this?
Yes, ma'am.
And what is that?
State's Exhibit 46 is a lab report for BCI laboratory number 23-17110.
And is that a report that you prepared?
Yes, it is.
And is it in relation to testing completed in this case?
Yes, it is.
And according to that, when was the evidence received by the lab?
The evidence was received on July 24th of 2023.
I'm next going to hand you what's previously been marked as State's Exhibit 47 for identification purposes. Do you recognize this?
Yes, I do.
And what is that?
State's Exhibit 47 is the K-Pack containing the item for BCI lab number 23-17110.
And did you again use the previously discussed testing methods to determine the identification and weight of that substance?
I did.
And again, when you weighed it, did you remove it from the bag?
I did.
And in your expert opinion, based on your testing, education, and experience, what was the weight of the substance contained in State's Exhibit 47?
State's Exhibit 47 was found to contain 2.57 plus or minus 0.05 grams of methamphetamine.
And again, did you follow the controls to determine that you were doing the testing properly in this case?
I did.
And in your expert opinion, based on your testing, education, and experience, what was the substance found in State's Exhibit 47?
State's Exhibit 47 was found to contain methamphetamine.
And what did you do with this evidence after you analyzed it?
After I analyzed it, I did issue my report with my findings and again sealed the evidence and returned it to a drug vault to be returned to the department.
No further questions.
Ross,
Your Honor, I just have a couple brief questions.
may proceed.
Thank you, Your Honor. When you say contain methamphetamine, does that mean that the entire grams that you weighed is methamphetamine, or is it just a portion of it?
I'm going to object. It's not relevant.
Stay.
No further questions, Your Honor.
All right. You may step down. Thank you.
Your Honor, may I be released to return to London?
Yes, you may.
Thank you.
And Ms. Miller as well. All right. Your next witness.
Joy Debo?
Were you sworn in the clerk's office?
Yes.
All right, if you have a cell phone, make sure you turn it off. Just have a seat over there. And microphone's already pulled in. You may inquire.
Thank you. Please state your name for the record.
Joy Debo,
And can you spell your last name for us?
DEBO.
Have you watched
Excuse me, I
it?
forgot to ask, we're broadcasting on YouTube. Do you wish to have your picture shown?
No.
All right, I did make sure it's not. Go ahead.
Have you watched any of this trial on YouTube?
No.
Are you familiar with investigator Randy Sanders and investigator Chris Bowen?
Yes.
How are you familiar with them?
Through dealings.
Do you know Steve Debo?
Yes.
And how do you know Steve?
He's my husband.
Now, in 2022, or I'm sorry, prior to 2022, were you using illegal narcotics?
Yes.
And about how long did you use?
About 2 years, maybe?
In 2022, did you begin working with Randy and Chris in undercover drug buys?
Yes.
And how did you decide who to buy drugs from?
I just had to come up with a person, a name.
Is it somebody that
I-
you knew?
Yeah, that I know, that I previously had purchased before.
Did you advise Chris and Randy that you could purchase illegal narcotics from Stephen Weil?
Yes,
And how did you know that you could purchase drugs from him?
because I had previously purchased them before.
And do you see Stephen Will in the courtroom
Yes.
today? Can you point him out for the court, please?
It's right over there.
Please let the record reflect the witnesses identified the defendant.
So ordered.
Now, when was the last time that you saw the defendant?
The last transaction?
So is that in 22?
Yes.
And since then, is there something that's different about his appearance?
Yes, he's got facial tattoos.
He didn't have facial tattoos then?
No.
I want to talk about December 5th of 2022, the sheriff cruiser deal. Do you remember that?
Yes.
Now, what type of drugs were you planning to purchase?
Meth,
And how did you set up the deal with the defendant?
through text messages.
My first witness,
You may.
getting into a series of pictures here, starting with State's Exhibit 6 for identification purposes. Do you recognize this?
Yes.
And what is this?
That is Stephen's contact information on my phone.
In your phone?
Yes.
So that's a picture from your phone?
Yes.
Okay. And State's Exhibit 7, do you recognize this?
Yes.
And what is that?
Let's see. That's just me starting the conversation to try to buy drugs.
And what did you say to him?
I said, hey, it's Joy, anything going on?
Okay. Next is State's Exhibit 8. Do you recognize this?
Yes.
And what is that?
That's me texting him saying I need a couple balls.
Okay, what are you talking about?
8 balls.
8 balls?
Yeah.
Okay, and is this a drug term?
Yes.
State's Exhibit 9. Do you recognize that?
Yes.
And what is that?
That's just telling me that I'll take 2 and let's see. And I didn't want to meet anybody else, so we just meet in Morristown.
Okay, I'm going to go back to State's Exhibit 8.
Okay.
Are you quoted a price for the 2 8-balls in that?
Yes.
And how much?
$120.
Okay. Next, going to show you as previously been marked as State's Exhibit 10 for identification purposes. Do you recognize that?
Yeah, that's saying that we're going to meet by the gas station or school, whatever's convenient.
Okay. State's Exhibit 11, do you recognize that?
Yeah.
And what is going on here?
Just stating if I needed them together or separate.
The 2 balls?
The 2 balls, yes.
Okay. State's Exhibit 12, do you recognize that?
Yeah.
And what's going on there?
That's just me telling me you can put it in one package.
So you can put the
2
8
balls
in
and,
one package.
yes, into one package.
State's Exhibit 13.
Yeah, that's just him asking me when, I guess the text, you want to get close? And then I told him I'd meet him at the gas station at about 10.
Okay. State's Exhibit 14.
Me telling him I'll be there in about 10 minutes and that he'll head that way. And what kind of car am I gonna, I'm sorry, what car am I gonna be in?
Okay. State's Exhibit 15.
Yep, that's me saying I'm gonna be a white Ford Ranger and then my husband's with me.
State's Exhibit 16.
That was me telling him there was a sheriff on my ass. But the sheriff was on my ass and I needed to turn.
So as you and your husband are headed to the deal, there's a sheriff's cruiser that's behind you?
Yeah,
And was this part of the plan?
no.
State's Exhibit 17.
That's telling me that the sheriff went straight through town, so.
Okay. Now, these messages, all the pictures that we just looked at,
Mhm.
these are taken from your phone?
Yes,
And were these all taken on December 5th of 22?
yes.
Now, based on the text messages, where was the deal arranged to take place?
Morristown gas station, the marathon there.
Okay. And who drove you to the Morristown gas
Steve
station?
Debo.
I'm sorry,
Steve Debo.
your husband?
Yes,
Now, prior to going to Morristown gas station, did you meet with Randy and Chris?
yes,
And did they search you?
yes,
Did they search your husband?
yes,
Did they search your vehicle?
yes,
Did they provide you with money to purchase methamphetamine with?
yes,
Did they provide you with an audio and video recorder?
yes.
And where did you place the recorder? Where did you place it in the vehicle?
In the center console.
Now, after they provide you with all this and they search you, what happens next?
We drove right to Marathon.
To the gas station?
Huh?
Now, at some point, did you have to turn off?
Yes, we did because there's a sheriff right behind us. So we turned off and then I believe just turned into a cemetery and then just turned around and came back out.
Okay. And during the time that you turn off, are you talking with anyone? Is anyone giving you instruction?
I want to believe Randy was
Okay.
because he said turn off because it did not.
Objection.
Just for-
Well, sustained is what he said. This jury will
Okay,
disregard.
so based on what he told you, did you turn off?
Yes.
Okay, and then what?
And then we just went right to Marathon.
Okay. Now, when you arrived at the gas station, did anyone come to your vehicle?
Yes.
And who was that?
Stephen.
And what happened when he walked to your vehicle?
He handed me the meth. I handed him the money.
Now, after the deal was finished, what did you do?
We got gas.
What did you do with the bag that he gave you?
I put it in the center console and just kept the camera on.
Now, when you paid for the gas, did you go into the store?
Yes.
Did someone follow you into
Randy
the store?
did.
I'm sorry, who?
Randy.
Upon meeting back with Randy and Chris, what happened?
We got searched. I got searched. My husband got searched. I believe Chris took the meth, and then they searched the vehicle.
Did you also turn over the audio and video recorder?
Yes.
On December 8th, did you again arrange to purchase drugs from the defendant?
Yes.
Now, this is the deal where the truck wouldn't start. Do you remember
Yes.
that? And what type of drugs were you buying?
Meth.
And how did you set the deal up with the defendant?
Text message again.
They hand you what's previously been marked as State's Exhibit 26 for identification purposes. Do you recognize that?
Yes.
And what is that?
That's Stephen's contact on my phone.
And that's a picture of your phone?
Yes.
State's Exhibit 27, do you recognize that?
I'm sorry. Let's see. Yes, that's just me saying, I'm sorry. It just says, hey, what's up? And I'm telling him I get off work at 4:30.
Okay. State's Exhibit 28.
Asked him if he's around, tell him I just got off work.
And State's Exhibit 29.
Okay. Him telling me that he's in Walmart and he's getting ready to leave town. I told him I'm on my way now. And he asked me if I remember where his house was at.
Okay. And finally, State's Exhibit 30.
Okay. This is me telling me, yeah, right past the sign where the driveway split.
Now, based on the messages, where was this deal arranged to take place?
Danville at his home.
And who drove you to your home?
Steve Debo.
And prior to going, did you meet with Chris and Randy?
Yes.
And did they search you and your husband?
Yes.
And did they search your vehicle?
Yes.
Did they provide you with money to purchase the meth?
Yes.
Did they provide you with an audio and video recorder?
Yes.
And what happened once they searched you and gave you the money and the audio and video recorder?
We headed to Danville.
And did you arrive at the defendant's home?
Yes.
And when you arrived there, did you make a phone call?
I want to say it was a text message
Did you, to who?
to Stephen.
Did you ask him to come out?
Yes.
When you arrived at his home, did you come to your vehicle?
Yes.
And what happened when you walked out to your vehicle?
He handed me the meth. I handed him the money.
Now, after he handed you the meth and you handed him the money, what did you do with the meth?
I put it in the center console.
Now, when you got ready to leave, what happened?
This truck would not start.
So, how did it get started?
Steve had to get out with starter fluid and spray something, and it got started.
So after the truck did get started, what did you do?
Pulled out and met with Chris and Randy.
Upon meeting back with Randy and Chris, what happened?
I believe Chris took the meth, and then Randy searched me and searched Steve, and then I think they both searched the vehicle.
Did you turn over the audio and video recorder?
Yes.
On December 28th of 22, did you again arrange to purchase drugs from the defendant?
Yes.
And to remind you, this is the cigarette deal.
Yes.
Now, what type of drugs were you buying?
Meth.
And how was this deal arranged?
Through text message.
I'm going to hand you what's previously been marked as State's Exhibit 37 for identification purposes. Do you recognize this?
Yes.
And what is this?
This is the contact information on my phone.
And State's Exhibit 38.
This is me asking him if he was going to be available that afternoon, and he'd be at the house. And then I asked if he'd be able to meet in Morristown around 5 or 5:30.
State's Exhibit 39.
Him telling me he doesn't have a vehicle, so he couldn't guarantee it, but he's going to make some calls, see if he can get around. And let's see. Me asking him if he couldn't get a ride, how else could we could do it. And he said, stop here in Danville and get it.
Okay. State's Exhibit 40.
Me asking him how much he's got on him, and that way I knew how much money I would need to bring. He said he only had 2.5 grams left for 50.
Okay.
And I said I was on my way.
And finally, State's Exhibit, not finally, but State's Exhibit 41. Do you recognize that?
Yes.
And what's going on there?
He asked if I could pick him up a pack of cigarettes, any kind. And I said, I'll give you what I've got. I almost got a full pack.
And State's Exhibit 42.
Same thing, I was just giving him the pack of cigarettes that I needed to get the car back. And I'd be there in a few, and he said, I'll be watching for you.
Now, based on the messages, where was the deal arranged to take place?
At his house in Danville.
And who drove you to his house?
Steve Debo.
Prior to going, did you meet with Randy and Chris? Or I'm sorry, did you meet with Randy and Detective Horn?
Yes,
And did they search you?
yes,
Did they search Steve?
yes,
Steve Debo being your husband?
yes,
And did they search your vehicle?
yes, they did.
Did they provide you with money to purchase the meth?
Yes,
Did they provide you with an audio and video recorder?
yes.
And once they provided you with all that and they searched you, what happened?
We drove to Danville, and the same thing happened. Steven came out. He handed me the meth. I handed him the money, and and the cigarettes, and then we left.
And when you left, what did you do?
We met up with Chris and is it Detective Horn? I can't remember the man's name.
You met with detectives?
I met with Chris, and I cannot remember, I'm sorry, the other officer's name.
And did they take the audio and video recorder?
Yes,
Did they take the ice?
yes,
And were you and your vehicle searched again?
yes,
Now, were you paid for your work
yes,
when you worked with Randy and Chris? And paid based on the deal that you did?
yeah.
I had no further questions.
Cross.
Thank you, Your Honor. Ms. Debo, my name is Tyrone Borger. I'm the attorney for Mr. Weil. Got a couple questions based off of your testimony.
Okay.
First, you had indicated that you had known Stephen. How long have you known Stephen?
Maybe 4 months prior,
4 months prior?
maybe 4 to 6, maybe. Not very long.
You had indicated that you previously purchased from him?
Hmm?
Right. Would that have been the 4 months prior?
Yes.
Well, how did you come to know Stephen?
Through a mutual friend, because I was using drugs at the time, and I had ran him out there to pick some up, and
The friend?
Yes. Trying to remember the friend's name. But he took me out there, and we also dropped off some firewood.
To Stephen?
Is this Stephen? Yes.
Yeah. Well, how did you get introduced to Stephen? The mutual friend, is that what you're
Yes.
saying?
Yeah.
Okay. Did you ever use with Stephen?
No.
No?
No.
You indicated that you got paid for these transactions, is that
Yes.
correct? All right. Did your husband also get paid?
No.
No, just you?
Yep.
But your husband was with you each and every time?
Yes.
Okay. You'd indicated that when you went to these alleged buys, that you were searched. Describe that at the outset. Describe that for me.
The search,
Yes.
they go under the bra, behind the ears, and you run, around your waistband and waistband of your panties, in between your toes. I mean, they search everywhere.
Where was that done?
That was done,
Objection.
What did you say? What was the question?
Where?
Where was the search done?
Overall.
let's see, the first time it would have been done, let me think.
Judge, may we approach?
All right, who approach? Just wait a minute. Okay, we're going to move on. Ask another question, please.
Thank you, Your Honor. Tell me again, how thorough was the search?
Very thorough,
Very thorough.
yes.
All right. Was it private?
In the area we were at, it was private, yes.
Fair enough. How did you determine the December 5th meeting points?
Like to be searched or for the purchase of drugs?
For the transaction?
What was ever convenient for Stephen, really, because I don't think he had a vehicle.
He was walking?
He walked from Marathon. Yeah, I saw him walk from Marathon, yes.
All right. Okay, what time did it say it stopped?
It's about 10 seconds.
About 10 seconds? All right, go back and ask, if you can remember, just so we get your question on. I think we missed one, possibly two questions.
How did you determine where you were going to meet for the transaction?
It was whatever I think was convenient for him.
All right. So did you ask him where was convenient? Is that what you're suggesting?
I believe it was like whatever works for you. I believe is what I said. I want to say that's what I've said.
Did you know where he was when you contacted him?
Not exactly.
Not
I knew the
exactly.
area. I didn't know exactly where he was, no.
Let's kind of back it up a little bit. You had his number in your contacts?
Yes.
All right. And that was just from 4 months ago?
Yeah.
All right. In that 4 months, how frequently did you contact him?
The 3 times. The 3 other buys.
Just the 3 times?
Yes.
So what you're suggesting is that you contacted him one time and said, I want to purchase some methamphetamines.
Yes.
And he said, sure,
Yes.
off of a relationship that had just begun 4 months prior.
Yes.
All right. And nobody else except for somebody that you had a mutual friend with introduced you to Mr. Weil.
Yes.
But you know you didn't have a vehicle.
And I said I didn't believe he had a vehicle.
Okay.
Because the reason I had to take firewood out to him that time, because they said he didn't have one, but I didn't know if he'd purchased one between that 4 months' time.
Okay. When you say you took firewood out to him, where did you take the firewood?
To Danville.
At his house? Okay. Are you suggesting that the only 3 times that you texted him was for these alleged purchases?
Yes.
Okay. I want to go back to the state's 3 exhibits. May I approach the witness, Your Honor?
You may.
State's Exhibit 6. What was that again?
That is his contact information on my phone.
Contact information for your phone. State's Exhibit 26. Is that what is that?
Yeah, same thing, contact information on my phone.
Okay. And then State's Exhibit 37.
Same thing, contact information on my phone, except it has a picture with it now.
Why does it have a picture with it now?
I was just updating through my phone and scrolling, putting pictures with faces, that was it.
So for the last transaction, you put pictures of Mr. Weil
I sure did.
into the contact information?
Yes,
Yes?
yes,
But you're a confidential informant, right?
yes.
I mean, this would presume that you're like friends. Are you friends?
Not really, no,
No?
no.
I mean, you knew that you were working with the task force, right?
Yes,
Right? And you knew that you were trying to get him to sell you methamphetamine,
yes.
right? Did you put a picture of him and his daughter on your contacts?
I really didn't think about putting his daughter on there, but it was his Facebook thing. I just put it on there.
Okay. Did you get friendly with him over the 3 times?
No,
No?
no.
Tell me again, after the December 5th purchase, alleged purchase, first of all, where did you meet?
The first purchase was at Marathon in Morristown.
Okay. Is there anything significant about the marathon in Morristown?
No, I mean, there's not much in Morristown besides the gas station, so.
All right. Is there any reason why you selected the gas station in Morristown?
I don't want to say I'm the one that said Morristown gas station. I think he was in Morristown.
All right. Did you discuss the meeting point with law enforcement?
Yes, they knew where it was going to be at because they had to follow us.
Did they ask you to suggest that meeting place?
No,
No?
no.
You and Mr. Weil on a first-name basis at that time?
Yes,
Yes? You text him and the first thing you say, is there anything going on?
yes.
How do you know it's him that's answering the text message?
I would just have to assume it was him.
Did you call him and speak to him on phone?
No,
For any of those transactions, did you call him and speak to him on the phone?
no,
No? You didn't call for the second or third transaction when you got to his home?
no.
No?
I believe I did on the 3rd.
Okay. Did he answer the phone?
Yes, no, a female did.
A female did?
Yes,
Okay. Obvious that it wasn't Mr. Weil, correct?
no.
Okay. After the December 5th alleged transaction, all right, and again, this is at the gas station.
Mhm.
How much time did it take?
For the actual transaction,
Yes.
probably less than 30 seconds.
Okay. And you're absolutely certain that it was him that met you at the gas station?
100%, yes.
How are you absolutely certain?
Because I looked at him he was right here next to my window.
How many times have you seen him prior to that?
I had seen him once.
Once. So you recognized him without any question after meeting him once.
Yes.
And when was that once that you met him?
Like I said, probably about 4 months earlier.
4 months prior. I'm trying to understand this. 4 months prior, you meet with him one time. And you're so certain that he is going to sell to you, first of all, that you feel comfortable texting him and saying, hey, it's Joy. And that's the first time you had contacted him in 4 months.
Yes.
And he's so comfortable with you that he's like, okay, that's what your testimony is?
Yes.
And you're also testifying that after meeting him one time, and you testified you were using, correct?
Yes.
All right, and were you using when you met him?
Like, was I high when I met him that night?
Yes.
No, I wasn't high at that time.
All right, did you meet him at daytime or nighttime? The
Nighttime.
first time?
Nighttime.
Nighttime? With the mutual friend?
Yes.
Okay. And I think you testified that you met at his house?
Yes.
All right. And did you go into the house that night?
Yes.
All right. Did you stay there?
No.
No? How long were you there?
We were probably there about 20, 25 minutes.
20, 25 minutes? So You've met him one time for 20 to 25 minutes. You feel confident enough that you can contact him and confident enough that you recognize him without question.
Yes.
From one time meeting him when you were buying drugs 4 months prior.
Yes.
Let's go to the December 28th alleged transaction. On that day, you texted him again.
Yes.
And when you texted him, was the afternoon when you texted him? Do you remember what time?
No, was that the last meeting or the second meeting?
The last one.
The last one? It was closer to evening.
Closer to evening?
Yes.
Did you ask him to meet you?
Yeah. I asked if we could meet up so I could buy the drugs, yes.
Was he able to meet you?
I had to go to his house.
Do you know why you had to go to his house?
I didn't ask.
You didn't ask?
No.
Did you ask for how much you could buy?
Yes, I think I asked how much he had, yes.
If you know this, the answer to this question, has your husband ever met Mr. Weil?
No, not that I know of, no.
No. Right. So he had never seen him prior to driving you. Is that correct?
Correct.
Right. And did you drive to these transactions or did he drive?
He drove me.
He drove. And again, describe to me, after the transactions allegedly occurred, what was the process again? What did you do immediately after the transactions?
I would put the meth in the center console and then put the camera on it until we would arrive to Chris and Randy, or Chris and, I'm sorry, the other, I don't know if it's Horn or, I can't remember his name, but until we met with them.
Would they search you again?
Yes,
All right. Same procedure as when they searched you to begin with?
yes.
All right. But they searched you at the same location or different location?
Let's see. Usually we would meet back at the same location.
Okay. How long did it take you to drive from one location to the next? Let's take that individually, actually. How long did it take you to drive to the December 5th alleged transaction?
Let's see. Handville's probably 15, 20 minutes out. Probably 2 minutes through town. I would say probably maybe 20, 30 minutes.
All right. And in that transaction that allegedly occurred, you actually, if I recall correctly, turned off because the sheriff was on your ass, is what I think you
Yes.
said, correct?
Yes.
All right. And where did you say you turned off to?
Oh, it's, I can't remember the name of the road. It's Wildcat, or it's like right by a cemetery. Maybe it's Wildcat. I don't know Morristown that well, so.
Okay. Were you being followed by law enforcement on these transactions?
I was being followed by,
Not the sheriff, I'm saying, but the people that were assisting you in
Yes.
setting up.
yes,
Were you followed by them?
yes.
Right. And when you turned off, did they follow you where you turned off?
I want to say yes, because we were on the phone with Randy, because we needed to turn off because of the sheriff being right behind me.
Matter of fact, you told Stephen that the sheriff was behind you.
Yeah.
When you turned off, did you get out of the car?
No,
When you got to the gas station, you did get out of the car after the alleged transaction occurred, is that right?
yes.
Right. How long did you stay in the car before you got out of the car?
Enough to back out of a parking spot into where a gas pump was.
I'm not sure I understand. So
I stayed
when you
in-
went to the gas station, where did you park?
We parked in the parking lot up against the building.
Okay.
And the gas pumps were right here. And we were parked like right here. So we just needed to back the vehicle up.
Okay.
But we needed to make sure we were able to get out of the vehicle to get gas.
Did you go in and pay for the gas?
Yes.
All right. Did you get anything else while you were in the gas station?
No.
Nothing?
No.
Candy bar?
No, just gas.
Okay. Use the restroom while you were in the gas station?
No.
No? For the December 8th transaction. That was 3 days after December 5th, of course. How did you communicate with Stephen?
I'm sorry, I didn't hear what you said.
How did you communicate with Stephen on December 8th?
Through text message.
Always the same number?
I'm sorry?
Always, did he always have the same number
Yeah, I
throughout
believe
this?
so.
Yes. And again, back it up to the first time you met.
Mhm.
All right. Did he give you his phone number that night? The only time that you met prior to this, by the way?
I want to say yes.
He did.
Yes.
Perfect stranger, first time he's met you,
Mhm.
gave you his phone number.
Yes.
You indicated that you got compensated for these transactions, is that right?
Yes.
How much?
Oh, goodness. I can't recall.
$100? More? Less?
I really can't recall. The exact amount, I can't tell you.
Did you get any other compensation besides money? A reduced sentence?
I didn't get any charges brought up against me because I was going to get in trouble.
So you were going to get charged,
Mhm.
and because you cooperated, they did not charge you, is that correct?
Correct.
Right? Not asking names, but there were other, strike that. Were part of the terms of you not getting charged a specific number of people that you needed to work with?
I believe so, yes.
Okay. Stephen would be one of those.
Mm-hmm. Yes.
So male officers or female officers that searched you?
Male?
Male? Both before and after?
Yes.
All right. No female officers?
No.
No? Did they make you take off all of your clothes?
No.
No. May I have just a moment to confer with my client?
Okay.
I'm not trying to beat a dead horse, but I want to ask a different question that I've already asked similar. Do you know if Stephen knows any of your children?
Yes.
Objection, relevance.
Overruled.
What's the
Yes.
answer? Yes?
Yes.
And how does he know your children?
I think, well, I know him and my oldest daughter went to high school together.
Okay. Then he had never seen or been in your home prior to?
No,
Has he ever been to your home?
no,
Never?
no.
I have no further questions.
Redirect.
Thank you. I want to talk about the December 5th deal first. First, did you purchase meth from this defendant prior to the December 5th deal?
Yes,
Okay. Now, Mr. Borger asked you several questions about who decided where to meet and things of that nature. So I'm going to show you some pictures you've already identified. States Exhibit 8, 9, and 10. States Exhibit 8. Can you tell me which one is which?
I'm in the green and his is in the black.
Okay, and what does that text say?
His text or mine?
Both.
Both mine says, I need a couple balls. His text says, I can do 2 for 120 if you can come and get them in Morristown right now. Truck's down for the moment.
So he tells you to come to Morristown? States Exhibit 9.
Okay,
And who's that speaking?
that is me.
And what do you say to him?
I said, okay, I'll take 2. I don't want to meet anyone, so when I get there, can you just come out? I own a house in Morristown, and I don't want my business out there.
And finally, States Exhibit 10. Is the green the rest of this text?
Yes, it says, I don't want my business out there, if you know what I mean.
And then what does he say?
He says, yeah. Like, I can meet you at the gas station or whatever. I'm down by the school, whatever works for you.
So who decided where to meet?
Stephen did.
So he told you to meet him at the gas station?
Yes.
Now, this picture that Mr. Borger talked about on your contact, is that from Facebook where you synced your phone to Facebook?
Yes.
Now, the question was asked when you texted this person, how do you know it was Stephen? But who showed up after the deals were arranged?
Stephen.
The person that you identified as Stephen in the courtroom?
Yes.
You said that you phoned him during one of the deals to ask him to come out.
Yes.
A female answered?
Yes.
Did someone identifying themselves as Stephen answer, get on the phone?
Yes.
And then did someone come out to your vehicle?
Yes.
Who came out to your vehicle?
Stephen.
The one that you identified here in
Yes.
court? Talk about the last deal. Again, you were asked about who suggested that you come to his house. I'm going to show you what you previously identified as States Exhibit 38. What is that?
Okay, that's me and Stephen's conversation. Let's see. Okay, I'm in the blue. He'd be the gray.
Okay, and what do you say to him?
I said, would you be available this afternoon? He said, yeah, what's up? I'm just at the house tinkering with stuff, laugh out loud. I said, would you be able to meet me in Morristown around 5 or 5:30 this evening? He says, I don't have a vehicle.
Okay. And States Exhibit 39 is the rest of the text.
He says, I don't have a vehicle at the moment, so I couldn't guarantee it. I could make some calls and see if I can get a ride that way around that time. And I said, what would I, Jane, to do otherwise? And I said, because I screwed up, I said, have not, Jane Doe. So he said, stop here in Danville and get it.
So he told you where to come?
Yes.
And was that the case? Did he decide where you would meet in all three deals?
Yes.
Now, during these deals, there was a lot of question about if you were searched and how thorough. Joy, did you stuff this methamphetamine inside of your body somewhere prior to the deal taking place?
Absolutely not.
When you went into the gas station during the first deal, did anyone follow you in?
Yes.
Who?
Randy Sanders.
The investigator?
Yes.
And So the first time that you met the defendant was when?
Probably about 4 months prior to that,
Okay, and where did you meet him at?
at his house
Okay, and why did you go there?
to buy meth.
You went there to buy meth?
Yes.
So, and how did you get there?
I drove.
Did you take somebody else with you, someone that knew him?
Yes.
Okay, so the first time that you met him, you went with a friend to his house?
Yeah. Oh, yeah. It was a friend of his. Yes.
So like a mutual friend?
Yes.
And when you went there, did you purchase meth from the defendant?
Yes.
One moment. I have no further questions.
All right, thank you. You may step down.
All right. Thank you.
And don't discuss your testimony with anyone. All right, it's 11:51, so I think we'll break for lunch now. If you wouldn't be in the jury room, so we can start back promptly at 1 o'clock. And it looks like, you know, like I said, the case will get to you sometime later this afternoon. If we can, we'll break during the eclipse, so you can look out and see it or go outside if you want to. You know, that way you'll be able to see it and not have to tell your grandkids, where were you when the eclipse came, say, well, I was on jury duty. So anyway, remember the admonitions of the court, and be back by 1 o'clock in the jury room. Thank you.
Please rise.
Thank you. Be seated, please. All right, thank everybody for being back early. So we'll go ahead and resume your next witness,
Steve Debo.
Steve Beaton. All right, remind everybody to turn off your cell phones. Stop right there. Have you been sworn in the clerk's office?
Yes, sir.
All right, and if you have a cell phone, make sure it's off. And this is being broadcast on YouTube. Do you want to be shown or not? All right, go ahead and have a seat there. All right, you may, I'm sorry, pull the microphone over there as far as it'll go, and make sure to keep your voice up. All right, you may inquire.
Please state your name for the record.
Stephen Debo.
And have you been convicted of a felony in the past 10 years?
I have
And what was that?
trafficking.
Were you a drug addict?
I was.
How long have you, are you still using drugs?
No, I'm not.
And how long have you been clean?
2 years.
Do you know Joy Debo?
I do.
And how do you know Joy?
She's my wife.
Do you know Stephen Weil?
I do.
And how do you know Stephen?
He was someone that we gotten drugs from.
And do you see Stephen in the courtroom today?
I do.
Can you play him out for the court?
Sitting at the defendant's table.
Please let the record reflect the witnesses identified the defendant.
So we're,
And does he look different than the last time that you saw him?
He does.
And what's different about him?
Tattoo on his face.
Do you know Randy Sanders and Chris Bowen?
I do.
And how do you know Randy and Chris?
They're detectives with the task force.
Now, following your conviction, did you start working with Randy and Chris?
That's correct.
And why did you do that?
It was part of my plea agreement and to get out of trouble.
Now, on December the 5th of 22, did you work with Randy and Chris? And we've kind of talked about this deal as the cruiser deal. Do you remember that?
I do.
Now, take us through what did you do that day?
I drove my wife to Morristown to meet Stephen at the Marathon gas station.
Prior to driving your wife to the gas station, did you meet with Randy and Chris?
We did.
And did they search you?
They did.
Did they search Joy?
They did.
Did they search your vehicle?
Thoroughly.
And you were the driver?
That's correct.
So while you're driving to the gas station, what happened?
We encountered a sheriff on one of the side roads on the road leading over to Morristown.
And what did you do?
Panicked a little bit and pulled into the gas station to, I think, get fuel either before or after.
When the cruiser was behind you, did you make contact with anybody?
I did. I reached out to Randy.
And did he direct you on what to do?
Told me to go to the Marathon.
Prior to that, did you turn off on a side road?
I don't recall.
When you got to the Marathon gas station, did someone walk up to your vehicle?
They did.
Who walked up to your vehicle?
Stephen Weil.
The Stephen that you've identified in the courtroom today?
That's correct.
Were you watching what happened when Stephen walked up to the car window or the truck window?
Yeah, I was paying attention.
Okay, and what did you see?
There was a transfer of methamphetamine through the window of the truck.
And did you see Joy give him anything?
She gave him some money.
After that, what happened?
We got some gas. We were out of gas. And so my wife went into the store. Randy followed her in. And then we went and met with the detectives.
And when you met back with them, did they search you again?
Same procedure. Thoroughly patted down and checked her truck again.
Okay. On December 8th of 22, did you again work with Chris and Randy?
I did.
And this is the deal with the truck broke down.
Yeah.
So what did you do on that for that deal?
I drove
Okay.
over to 138.
Did you have Joy with you?
She did. She was with me.
Did the two of you meet with Randy and Chris prior to the deal?
Yes, we did.
Did they search you?
Thoroughly.
Did they search your vehicle?
Thoroughly.
And then you drove to the house on 138?
Yes, ma'am.
When you arrived at the house, do you recall what happened?
Stephen came up to the window, and same thing was some small talk and then exchange drugs through the window for some money.
Okay. And as you were preparing to leave, what happened?
My truck wouldn't start.
So, how did you,
I panicked again and reached out to Randy.
how did you get it to start again?
I had to get some starting fluid to get it to come going again.
And then did it start?
Yes, it did.
Okay, and when you left, did you meet up with Randy and Chris again?
Yes,
And when you met with them, did they search you again?
same procedure. Patted us down and checked our truck thoroughly.
Okay. On December 28th of 22, did you again work with Randy?
We did.
And we've talked about this deal today is when Joy provided cigarettes. Do you remember this?
Yes.
And what did you do?
Drove.
Again, drove Joy?
Yes.
Did you meet with Randy and Detective Horn prior to the deal?
Yes. Yes, we did.
And did they search you
Thoroughly.
and Joy
Yes, ma'am.
and your vehicle?
And the truck.
And did you again drive Joy to the location?
Yes, I did.
And do you recall where that was?
That was on 138 again, I believe at Stephen's house.
Okay. And when you pulled in, did someone come out to your vehicle?
Yes.
And who came
It
out?
would have been Stephen's. Weil.
And did you witness the transaction?
Yes.
And along with the money, did Joy give anything else to the defendant?
Like a half pack of cigarettes.
And after that, did you leave?
Yes.
Did you meet with
Randy and the one detective that you mentioned, I don't recall his name.
Detective Horn?
Yes.
Did they search you again?
Thoroughly.
Did they search your vehicle again?
Thoroughly.
Now, prior to each of these, I'm sorry, I already asked you this. I have no further questions.
Ross?
Thank you, Your Honor. Good afternoon, Mr. Debo.
How we doing?
My name is Tyrone Borger. I am the attorney for Mr. Weil.
Okay.
So I've got a couple questions for you. Prior to December 5th, had you ever met Mr. Weil?
No.
No. Okay. And prior to December 5th, had you ever worked with task force?
Let me ask, was it December 5th the first deal?
Pardon?
Was it December 5th was the first deal?
That's
Yeah.
correct.
Yeah, I never met him before.
Never
that.
met before? Right. Prior to December 5th, had you ever worked with task force before?
Yes.
Yes. All right. And so, was that the first time that you had met somebody to make a transaction? On December the 5th?
I'm sorry, I'm not sure. What do you mean?
Had you met
I had worked with the task
different
force prior
person
to, yes,
before
yes.
December 5th? You had. All right, so you had some experience with being a CI, is that correct?
That's correct.
All right. And you're testifying, actually, you testified that you did this in order for, cooperate with task force in order to get a reduced sentence. Correct?
That's correct.
All right. You testified that you were searched thoroughly before going to the meat place. Is that right?
No, my sentence, can I correct myself?
Sure.
My sentence had already been conveyed. I was working with the task force to reduce my wife's sentence.
Okay, fair enough. Still had some motivation to cooperate with the
That's correct.
Okay. You testified that you had been searched thoroughly before going out to meet what you now know, or what you say you now know as Mr. Weil, correct?
Yeah, it's a little humiliating.
What's that?
The getting patted down, it's pretty thorough.
All right. Did you get patted down in front of your wife?
Yes, I did.
Right. And who did the patting down?
2 times it was Detective Sanders, and then the 3rd time, I think it was Chris Bowen.
Right. And when they patted you down, did they go underneath your clothes?
It was a pretty thorough search. I don't recall if they went under my clothes, but you feel humiliated, violated almost.
Did you see them go underneath your wife's clothes?
Yeah. Yeah, they had to make her remove her bra and the whole 9 yards.
Right. Just her bra, or does she have to remove any other clothes?
No, I don't recall removing anything else.
Okay. And this is the December 5th is when apparently there was a sheriff that got behind you on the way. How long was the drive?
About 20, 25 minutes.
Okay.
Maybe 20.
So when the sheriff got behind you, what did you do?
Well, from the time the sheriff got behind me to where the gas station is like a 3-minute drive. So I drove to the gas station there in Morristown.
You didn't deviate from your drive at all?
I don't recall going down. I do actually recall going down a little small side road and turning around and coming back out and going back to the gas station.
Were you being followed by law enforcement at that point?
We've been followed the entire time.
All right. Do you know if they turned into wherever you turned into to avoid the sheriff's deputy?
Did they turn into avoid the deputy? I don't recall them turning into avoid the deputy. I recall them following me.
What's that?
They followed me.
They followed you the entire time?
Yes.
All right. And so the question is, did they follow you when you deviated from the route?
Yes.
They did?
I
They
believe
turned
so.
right in there with you?
Yes.
Okay. And when you got to the gas station, right, did you see Mr. Weil at that point?
Actually, he popped up out of nowhere, so I didn't see him at first.
Okay. And I think you testified that at the gas station, after the transaction was alleged to have been completed, did you go into the gas station at all?
I believe it was my wife.
All right. Do you believe or do you know?
I don't recall for sure. I know that Randy followed her into the store.
All right. Did you go into the store?
No,
No, not at all?
no.
Okay. And so when Randy followed her into the store, how much time had elapsed after the alleged transaction took place?
Well, maybe a minute or two.
Minute or
That.
two?
Enough time to walk into the gas station.
All right. So walk me through this, though. Randy's law enforcement, correct?
Yes.
Okay. And so after the alleged transaction occurs, do you enjoy just sitting in the car?
I'm sorry.
Do you enjoy just sitting in the car?
After we got back in the car?
No. This is after the alleged transaction occurred, okay? Did you two just sit in the car?
I don't recall.
All right. Did Randy approach the car?
I don't remember Randy walking up to my truck, no.
All right. Where did you see Randy before Joy went into the gas station? Or, I'll
You
let you answer that one, sorry.
You don't usually see them guys. They're kind of covert, so I didn't really see him. I just seen him walking in behind her.
Okay, so Joy decided just to go out on her own before she had talked to Randy?
No, it was predetermined in a phone call.
Okay. So, Joy goes into the gas station before Randy actually got to the car. Is that what you're saying?
No,
No?
not,
Okay.
not as I recall that, no.
All right. Well, maybe help me understand this. Because I thought you just testified that Joy went to the gas station, Randy had not been to the car yet after the alleged transaction occurred.
Randy didn't come to the car. Randy followed her into the gas station.
All right, that's what I'm asking you. Did Randy come to
Yeah.
the car?
Right, no,
No. So Joy gets out of the car, goes into the gas station, right?
correct.
And you saw Randy follow her into the gas station, is
That's
that right? Did you speak with Randy before he followed her into the gas station?
By telephone,
Just by telephone, but
Yeah.
not in person?
no.
Okay. What did Joy do when she went into the gas station, if you know?
I have no idea.
I have no idea.
I
Did she buy
presume she
anything?
paid for gas.
Did she buy anything else?
No,
No? Candy bar?
no.
No? Okay. For the December 8th transaction, did you know where Mr. Weil lived?
December 8th, is that the first, second, or third transaction? After I went the first time to his house, I knew where he lived. Before that, I knew
Well,
approximately.
Let
I've
me
been told
clarify
about
for
it.
you, please. December 5th, I called the gas station, all right? The prosecutor called it something different, all right? December 8th is 3 days after that,
Okay.
okay? And supposedly you went out to Mr. Weil's home,
Yes,
all right? Had you been there before?
no.
No. Do you know if your wife had been there before?
I think she has.
Okay.
She'd taken an associate over there,
How long have you been married to your wife?
30 years.
30 years? Okay. So you've been through a lot together, I imagine.
Yeah.
Okay. So how long was the drive from where you had originally left to Mr. Weil's residence?
10, 15 minutes.
10, 15 minutes? Anything happened on the way over there? Anything remarkable?
No, not that I recall.
All right. Were you in contact with law enforcement on the drive over there
You're in contact with law enforcement the entire time.
the entire
I
time?
mean, they're on the, I'm not gonna, I mean, I'm not talking to him the whole time. I did, actually, I could talk to him one time, almost the whole way there.
What'd you talk to him about?
I don't, where I was going, what I was supposed to do, and that sort of thing.
Just because you had not really participated in many of these before?
No, they're all individually kind of different.
Were you nervous?
Well, sure.
Yeah. So you go to Mr. Weil's residence. Did you speak to him at all?
No,
Did you call him on the phone?
no,
You weren't the one that was text messaging him.
that was my wife.
That was your wife? So again, you had no prior knowledge other than 3 days prior of possibly seeing Mr. Weil, is that right?
That's correct.
Never saw him before?
I just wasn't gonna let my wife do this alone.
I understand. So the December 28th, that's the third one.
Okay?
Same procedure, your wife calls, or what, does she call or does she text Mr. Weil?
I believe it was text.
And did you meet with law enforcement before going out there?
Oh, absolutely.
All right. Same procedure where you searched prior to going
Thoroughly.
thoroughly, all right? Same procedure though, pat down?
Absolutely, yeah.
All right. Did you see your wife get patted down as well?
I did.
Same question I asked about the December 5th one. Did you see, did they go underneath your clothes at all to search?
I don't recall ever be going under my clothes. I just recall them having a remover bra again.
What about you?
I don't know. No,
No? Didn't go underneath your clothes at all?
no.
Didn't ask you to lift your shirt up,
Oh, yeah. Yeah,
Yeah.
you gotta do all that.
untuck it,
Yeah, you gotta show them your waist and all that.
drop your pants?
No.
No? All right, put the pat down.
Yeah.
Okay. Can I have just one moment, John? No further questions, thank you.
Redirect.
None, Your Honor.
All right, you may step down. Next witness.
And Randy Sanders?
Have you been sworn in the clerk's office?
I have it.
All right. And do you care whether you're shown on YouTube or not? Didn't think so, but.
Okay.
All right, you may inquire.
Thank you. Please state your name for the record.
Randy Sanders.
And are you currently employed?
I am
Where are you employed?
through the Highland County Prosecutor's Office.
And what are your job duties there at the prosecutor's office?
I'm an investigator with the Prosecutor's Office. We work with agencies, system and investigations, and we also run our own covert investigations.
Are you in charge of the Highland County Task Force?
I am
And how long have you been employed in law enforcement?
over 40 years.
During your career, have you taken any specialized trainings in illegal narcotics investigations?
I have.
Several?
Yes, I've taken a basic narcotics investigation course. I've taken a collection of basic collection of narcotics intelligence, advanced narcotics intelligence. I've done it with the heroin conference. I've been took a class in methamphetamine investigation management. I've been clandestine lab certification. I've also taken courses in task force operations and been in charge of task forces.
Your Honor, may we approach?
May.
previously worked on covert drug investigations
I have.
with different task forces or how?
Yes, I've worked undercover with the, while I was with the Highland County Sheriff's Office. Also, I worked through, while I was still with the Sheriff's Office, through the Southwest Regional Drug Unit on a 9-county task force. I worked with the US 23 task force, which is based out of Ross County, and most currently with the Highland County task force. And also, during that time, I worked on 2 federal task forces, one with the DEA on a methamphetamine case and one with the FBI.
And what is a covert drug investigation?
That's something that we don't put out in the open from the start, not like a normal investigation, like a burglary or something. It's all secret till we get finished.
And about how many of these have you worked on?
Several thousand.
What roles have you played in these investigations?
I've worked them as an undercover officer. I've worked them as a surveillance officer. I've done the tech stuff on the deals. I've worked them as a case officer, as a supervisor, and then again while I was in charge of the task force.
And so when you say you worked as an undercover officer, have you actually done the hand-to-hand transactions?
Yes,
Now, through your role as an undercover, have you become familiar with drug words or words that are commonly used in the drug trade?
I have.
And can you tell us, what is a ball?
It's what they call an 8-ball, which is an 1/8 ounce by weight, which would be 3.5 grams.
Now, when you worked as, I'm sorry, what is ice?
That's methamphetamine.
So ice is just a slang word for that?
That's a slang word for meth, yes.
Now, when you worked as an undercover, did you make purchases from people that you had met one time?
I did, always, almost always.
Okay, explain that to us.
When I went out, there was only, in the years I worked undercover, I probably only knew a couple people by sight that I did the whole time I was doing it. And I did like several hundred drug buys.
So you would go somewhere, meet somebody, and then work yourself into buying dope from somebody.
That's correct.
In 2022, were you working on undercover drug operations here in Highland County?
Yes, I was.
Have you previously worked with civilians in undercover drug operations, used them to purchase narcotics?
Yes, we have.
And is there a procedure that you follow when you sign a civilian up to do this?
Yes, there is.
Can you take us through that?
Okay, we got forms and paperwork that we go through, which goes through a list of basically their information. We run backgrounds on them for their records. We go over rules and regulations that we have to go by, and therefore they have to go by during while they're working with us on these operations. We go through an interview with them of what they know, who they know, what they can do, what drugs they know about, and then we go a step further. We start introducing them to how we're going to do the deals. That each time we do a deal, they're going to be searched. They're going to use our equipment and what we look for in the deals. Once they get the dope back to us, that they're going to be searched. We also go over the safety for the CIs, what to do if we pretty much tell them at any time you feel uncomfortable, walk away. Because our number one priority is not getting anybody hurt on any side. I believe that's pretty much the gist of it.
Do you pay CIs for their work?
We do.
And how does that work?
It's usually, we start out, most generally, we pay a per deal price. We give them a per deal price. They do a deal, and it can go up from there depending on complications or what. We look at it as far as how big the drug dealer is or how much we're going to follow up on that case.
When you begin working with a CI, how do you decide who you're going to attempt to buy from?
It's all out of the interview with them, who they can do. We don't direct them to go look for somebody that they don't know or anything like that. Once in a while, we'll if they've named somebody they know, or we might ask them if they know somebody, but most generally it's people that they gave us that they tell us they can buy off of.
When you're doing a deal with a CI, do you immediately arrest the dealer as soon as the transaction is over with?
No, we don't do that. If we would do that, then one deal and the whole thing would be over with and done. The investigation would be finished.
Before a CI does a deal, is there a process that you follow every single time?
There is.
And can you tell us about that?
Yes, we search the CI or CIs and their vehicle. Then we provide audio, video recording equipment, and we provide the money for them to do the deal.
Now, this audio and video equipment, other than record what takes place, are you able to watch what's going on as it happens?
Yes, the video we're currently using, we can watch real time as it happens.
So in the three, were you present for all three deals in this case?
I was, yes.
So during the three deals, from the time the CIs get the video equipment, are you able to watch everything until they return to you
That's correct, yes.
as it's happening?
Yes.
Now, after a deal is complete, is there a process that is followed?
Yes, there is.
And do you follow the same process every single time?
We do.
And can you tell us about that?
Yes. We retrieve the drugs from the person that's made the purchase for us. We again search the CI or CIs, both of them, and again search their vehicle. And then after that, we do a recorded interview with the CI, having them tell us exactly what happened.
Now, before each deal, you either photograph or record the serial numbers on the buy money, but why do you do that if you don't immediately arrest the dealer?
That's done. We started doing that several years ago. So if we go, not necessarily in this investigation, but later on, if we do a search warrant somewhere at the house, we can go through that money and we might find monies from different deals. We've done that on several deals in the past where we've done search warrants, and I remember one particular, we had $25,000 out of a safe and we found money from, I believe it was 12 drug buys in that safe, so we knew it was money that, we knew where the dope was, that was where the dope was coming from at that point.
In December of 22, were you working with the CI that you called Julie Hess?
Yes.
Now, it's not a real name, is it?
No, it's not.
Why do you give the CIs fake names?
We do that basically because in our paperwork we do, one of the things we do is we get them to sign receipts for money that we give them, and anytime they sign a receipt, the one thing that we do know every time, auditors can look at our records. So we give the CI a fake name so their real name does not appear on those records of the money that we pay them. And then we also take another step. We get their thumbprint. We put their thumbprint on the back of those cards for two reasons. So if we ever need to know exactly for sure who it was, we can run the fingerprint, or it's also for our protection so nobody can't say we're taking money from there.
Now, did you go over the CI procedures? Let me back up just one question. Is the person that you called Julie Hess, is that Joy Debo?
Yes, it is.
Now, did you go over the CI procedures with Joy when you signed her up?
Yes, we did.
Did she advise you that she could purchase meth from Stephen Weil?
She did.
Do you see the person you know as Stephen Weil in the courtroom today?
I do.
Can you point him out for the court, please?
He's in a blue shirt with a black vest on.
Please let the record reflect the witnesses identify the defendant.
Sorter.
Now, prior to today, when was the last time that you saw Stephen?
December 28th of 2022.
Is there anything about him that's different than the last time you saw him?
Yes, the tattoos on his face.
On December 5th of 22, did you and Investigator Bowen conduct an undercover buy with this defendant? I'm sorry, what we've referred to today so far as the deal with the cruiser.
Yes, we did.
May I approach the witness?
May.
I'm going to hand you what's previously been marked as State's Exhibit 3 for identification purposes. Do you recognize that?
I do.
And what is that?
This is our surveillance report. It's basically a log of what we do that day that one of us keeps track of as we go along.
So that report, is it
Yes, it is.
And is it kept as part of your records with the task force?
It is, yes.
Now, can you tell us just briefly about the December 5th, 2022 deal?
Yes. We met with the CI and her husband, who was also a signed up CI, and they were searched. The vehicle was searched. We then followed them down to Morristown, and as we was on 321, a sheriff's cruiser got in behind them. So we directed them by phone to turn off on the next road to the left, which happened to be Wildcat Road, where they pulled up, and we pulled in up behind them, and both turned around and told them to follow us back so we could get ahead of them a little bit to make sure the cruiser didn't pull into the gas station where we planned to do the deal, and in the center of Morristown. They then followed us up, pulled in the gas station. We directed them to park in one of the parking spots, which they did. Immediately, the defendant Weil come up to the window, left. They told us what direction he walked, what he was wearing, and Investigator Bowen and I followed him out North High Street to a residence toward the White Oak High School. We then went back, and the CIs needed gas, and the whole time they done as they were directed. Once they bought the dope, they put the camera on the evidence on the dope which was laying on a orange vest, or I believe it was something orange, and when told him to go ahead and get gas, and I followed Joy Debo into the gas station when she paid for the gas, and she came back out, got in the car, and we followed him back to the meet location where we obtained, Investigator Bowen had obtained the dope from the car, and we again went through the search procedure and the interview.
And so, as you're going to the gas station, back to the part where you turn off to get away from this cruiser, the entire time are you guys live? Are you able to know what's going on in that truck the entire time?
Yes, we can see and hear everything in the truck, yes.
And how can you see and hear everything in the truck?
From the audio video recorder, because we're live with it constantly during the deal.
So you're like a third person in this Ford Ranger.
Yes.
And then when you leave the gas station, you follow the defendant. What's going on there at the gas station in the truck?
They're sitting there with the camera on the dope, and that's the way it stayed. Watched it until we got back, and then they got gas, and we watched, and then she went in to pay for it, and I followed her in the gas station back out.
And again, are you live this entire time, like you're watching and hearing everything in live as it happening?
Yes, of course I didn't. It was Investigator Bowen watching once I went in the gas station and followed her in and out.
Okay, on December 8th of 22, did you again work with the same CI to conduct an undercover buy with the defendant?
We did.
And the prior witnesses, we've talked about this as the deal where the truck wouldn't start. Do you recall this deal?
I do.
Okay. Going to hand you what's previously been marked as State's Exhibit 23 for identification purposes. Do you recognize this?
I do.
And what is that?
That's the surveillance report from December 8th, 2022. The deal you just referred to is the truck wouldn't start deal.
Was that report completed in real time as the deal was taking place and kept as part of your records with the task force?
Yes, it was.
And can you just briefly tell us about that deal?
Yes, the CIs in her vehicle was searched. They were given the money, and had already made contact and told us they was to meet Weil at his residence, which was on State Route 138 in Danville. We followed him. Again, gave him the audio video recorders and followed him to Danville, where they pulled in at 5005 State Route 138, which is, if you're going from Hillsborough to Danville, it's on the right just after you enter Danville. I believe it's like the third driveway. It's like a split driveway. They turned to the right, went up. Once they were in the driveway, Joy Debo made a phone call, and a female answered the phone. She asked if Stephen was there, and a male then got on the phone and was arranged for him to meet in the driveway. The defendant, Weil, then walked out, walked to the passenger side of the truck, which was where Joy Debo was sitting. You can see the money in her hand at the time. They made an exchange, and she placed dope again on in the middle of the truck, put the camera on it, and the truck wouldn't start. They sat there, and he had to get out of the truck to get it started. He got back in the truck. They drove away. We followed him back to the meet location where they were again. Again, Investigator Bowen collected the evidence from the truck, and it was, we again searched the vehicle and the CIs and done an interview with them.
And again, during this entire time, were you and Investigator Bowen able to see and hear everything that's happening in the vehicle as it's happening?
Inside the vehicle, yes.
On December 28th, did you again work with the same CIs to conduct an undercover buy with the defendant?
I did, yes.
And today we've talked about this as the deal where the CI gave out cigarettes. Do you recall this deal?
I do.
And can you take me through how this deal was arranged?
Again, CI arranged it through with messages to meet, and the time we got ready to go, the messages, the CI let me know through the messages that there was he only had 2.5 grams and he would take $50 for it. We first met the CIs at like 5:15, and on December 28th it was starting to get long toward dark, and so we tried to hurry a little bit to get the deal done before dark, because our cameras does not work well inside a vehicle after dark.
May I first witness?
You may.
Getting into what's previously been marked as State's Exhibit 37 for identification purposes, do you recognize this?
I do.
37 or 36?
37.
Okay, that's the picture. Oh, okay, I'm sorry. All right, thank you.
Do you recognize that?
I do.
And what is that?
This is a photograph I took of the CI's Joy Debo's phone after the deal was completed.
And State's Exhibit 38, do you recognize this?
I do.
And what is that?
That's another photograph I took of the conversation with Stephen Weil's name at the top. I took from Joy Debo's phone after the deal.
State's Exhibit 39?
Again, the same conversation with Stephen Weil.
State's Exhibit 40?
Yes, this is a message prior to doing the deal. I'm sorry. This is another photograph of from Joy Debo's phone that I took at the completion of the deal.
State's Exhibit 41?
Another photograph of the Joy Debo's phone I took at the completion of the deal.
And finally, State's Exhibit 42?
Another photograph that I took at the completion of the deal from Joy Debo's phone.
Not going to hand you, it's previously been marked as State's Exhibit 36 for identification purposes. Do you recognize that?
I do.
And what is that?
This is a surveillance report from 12/28/2022.
And is that a report that you completed in real time as the deal was taking place and kept as part of your records with the task force?
Yes, it is.
Now, prior to the deal, was the deal procedure followed in searching the CIs in their vehicle?
It was. That's correct.
And did you provide the CIs with an audio and video recorder?
I did. As part of that, I actually turned the audio and video recorders on myself and shut them off afterwards at the end of the deal.
So the CIs aren't able to do that?
No, we don't show them how. I do.
And what is that?
This is our money receipts. One's a cash expenditure voucher for the cost of the drugs we purchased, and the second is a informant payment for the deal itself.
Now, where is this deal said to take place, or set up to take place?
At Will's residence on State Route 138.
I'm next going to hand you what's previously been marked as State's Exhibit 34 for identification purposes. Do you recognize that?
I do.
And what is that?
That's a certified copy of the deed for the property at 5005 State Route 138. The property of Stephen Will.
Now, following the deal, when you met back up with the CIs and searched them, did you say that you took the audio and video recorder back?
I'm sorry, I didn't hear you.
Did you say that you took the audio and video recorder back from them?
That's correct, yes.
Next, going to hand you what's previously been marked as State's Exhibit 43 for identification purposes. Do you recognize this?
I do.
And what is this?
This is the video of the deal on December 28th, 2022.
Now, is this the entire video or only a smaller section of the video?
It's a smaller section of the video. It don't contain the entire ride from where we started from all the way down, and then again the ride on the way back.
But during the ride, are you or Investigator Bowen able to observe and see what's going on in the vehicle the entire time?
Yes, in this case it was me, yes.
Is this do you know who we are going to see and hear on this video?
Oh, we'll see Joy Debo and Stephen Will. I'm not sure. I know you can hear Steve Debo, but I'm not sure whether you see him in this clip of the deal.
Is this a true and accurate copy of the video from the deal on December 28th, 22?
It is, yes.
At this time, we would move to admit and publish State's Exhibit 43 to the jury.
Objection.
Objection.
All right, submitted, you may publish it.
Thank you. All right, now, what are you doing today? All right, there.
Now, following where it stops, is that when you meet up with the CIs again?
Yes, I follow them back. We follow them back to the meet location, and that's where we went through the collecting the evidence and again searching the CIs in their vehicle.
Going to hand you what's previously been marked as State's Exhibit 44 for identification purposes. Do you recognize this?
I do.
And what is that?
That's a photograph that I took from the, I took off the video that we just watched.
So that's like a still shot from that video?
Yeah, I took a shot with the camera off the video on the, playing on the computer.
Next.
You guys haven't, don't you? The other exhibits from this morning. I told them to give them back to you guys because they hadn't been proffered yet. Okay, well, we'll have to go get them. Go ahead.
That's it.
Well, you know, that's why I didn't want them, because, you know, it's not our job to take care of your exhibits until they're admitted. So ask another question while we're waiting on something else.
Our State's Exhibit 37 through 42 and 44, which are the pictures you've identified, true and accurate depictions of the scene as they appeared on December 28th of 22?
They are, yes.
At any point during the December 28th, December 5th, or December 8th, why did Steve or Joy exit the vehicle?
Steve did on December the 8th deal to get it started when it wouldn't start.
And during the entirety of all three deals, are you able to watch and see and hear what's going on during the deals?
Yes.
I'm going to hand you what's previously been marked as State's Exhibit 47. Do you recognize this?
I do.
And what is that?
This is the evidence, the methamphetamine that we collected from Debo's car at the end of the deal on December 28th of 2022.
And after you received that, what did you do with it?
I turned it over to Detective Vance North, the Sheriff's Office, to be secured, to be sent to BCI to be tested.
Now, are you familiar with, obviously you're familiar with all three deals. All three deals resulted in a plastic bag, of the meth being delivered in a plastic bag. Why were those bags not sent to BCI for fingerprinting?
We don't send the small bags to BCI. We've sent them in the past, like numerous times, and due to handling the drugs and stuff, BCI says they can't get fingerprints off the smaller bags like that, so we do not send small bags up to be fingerprinted.
What about DNA testing?
They have protocol. They won't test for DNA only in specific cases, which you have to request ahead of time on drug cases, and none of these fit the criteria for testing for DNA.
I have no further questions.
Cross?
Thank you, Your Honor. Good morning, Mr. Sanders. May I call you Randy?
That's fine.
Randy, my name is Tyrone Boger. I am the attorney for Mr. Weil. I just have a couple of questions based off of your testimony. First, I'm curious if you could walk us through the selection process of how you target somebody. You talked about this briefly as far as your testimony. And I believe you suggested that it's the CI that provides you with the name. Is that correct?
That's correct.
All right, then which of the CIs provided you with Mr. Weil's name?
First, it was Steve Debo that provided the name. He said that was somebody that Joy knew and Joy could buy dope from.
Okay. And had you had any contact with Mr. Weil prior to the December 5th?
No, I had not.
Oh, you ever heard of him before?
I'd heard the name, but I didn't know him.
Okay. For each of the buys, you said that there is a routine search process for your CIs, correct?
That's correct.
All right. When you search them, do you search them together?
No, separately.
Separately?
Yes.
So if there was testimony from one CI that said he saw his wife be searched, that be accurate or not?
That could be accurate. When I say separately, I mean just not like side by side, one and then the other. I mean, they're separated by a little bit of distance.
All right. How much of a distance?
It depends on where we're at. Most of the time, this is outside, so somewhere I would say average between 10 feet and 40 feet.
All right.
Maybe,
do you know
maybe
specific-
maybe on opposite sides of the car.
Okay. So specifically for the December 5th, do you recall how you conducted the search of both of these CIs?
Not the distance between them. I just know we do it each and every time. I mean, over the years, we've done this numerous times, and we know that one of the main things we've got to do is make sure that they can't transfer anything back and forth between each other while we're doing this. So we make sure we do it the same, where they're separated. We do the search of one and then go directly to the second one and do the search of them.
Did you personally conduct the search on December 5th? And then it's hard to remember.
I would have to refer to our, it's noted on our report that we do, on our surveillance report.
Okay. I'll move on from that. After the search is conducted, you then settle on where the transaction is to occur. Is that correct?
The time where the transaction is going to occur, that's mostly up to the person we're buying the dope from.
Okay.
So we either know about that at the time we meet with them or during the subsequent messaging where it's going to happen at.
Okay. So specifically again for December 5th this time around, how did you become aware that there was going to be a transaction?
We had talked to them ahead of time and made the arrangements to meet, and they had had contact with, through messaging with the defendant Weil, and we went from there. Found out he was in Morristown, and we was going to do the deal there.
Maybe I'm not asking the question as articulately as maybe I should. Do you prompt them to contact the proposed seller, or do they contact you that the proposed seller has contacted them?
I'm not sure which way it went in this direction. I mean, it works both ways. Most of the time, they get a hold of us and let us know that they have a deal that they can do. I won't say that's every time, but most of the time, that's the way it occurs.
And they tell you how much money they need, I'm assuming, for the deal?
No, we always decide. We try to always decide how much we're gonna buy. That way, they don't know ahead of time how much dope we're gonna get. It's just another safety feature we throw in, so nobody can't bring, dope and hide it somewhere and get by with it.
Fair enough. On this particular transaction, the meat was supposed to be at a gas station, correct?
That's correct.
All right. How did you learn that the gas station was where the transaction was going to be?
That was at the process of getting ready to do the deal. When they were talking to him, they told us he was in Morristown, and I believe during the messaging. It was his suggestion, the gas station.
You provide your CIs with audio in the video recorder?
Yes,
All right. You then follow them to the location, is that correct?
that's correct.
All right. And in this particular transaction, December 5th, you were the one that were following them, is that correct?
Me and Investigator Bowen were in the same vehicle.
Who was driving?
I was driving.
Okay. And this is the transaction where apparently a sheriff's deputy got behind your CIs, is that correct?
That's correct.
All right. Did you give them any instructions about what to do with the sheriff's deputy behind them?
Absolutely, I did.
And what did you tell them to do?
I told him to turn the next road to the left, and then once we got on would have been Wildcat Road, and once they turned down Wildcat Road, told them to just turn around and follow us back, because we'd followed them on the Wildcat Road, and we both turned around and they followed us back.
Okay, so it's just so I'm understanding, you're behind them, and you tell them to turn on to Wildcat Road, right? And they comply with you.
Absolutely, yes.
And as they comply with you, you then have them turn around and follow you. Is that what I'm understanding?
And we turned on Wildcat Road also.
Right?
And yes, and then I had them, when they turned around, we turned around too, and follow us to the deal from there.
Okay. So you were in the lead at that point where before you were behind them.
That's correct.
Okay. And so you drove to the gas station as well?
That's correct.
Did you park at the gas station?
No.
No. Did they park at the gas station?
Yes.
Okay. How far away from them were you as far as where you parked?
I don't remember whether we stopped and pulled in the gas station right away, or I believe we just drove on by at the time and just stayed in the area.
All right. And this is the first time that you had any encounter with someone that you believe to be Mr. Weil, is that correct?
That's correct.
Okay. Did you see him at the gas station?
Just seeing him from a distance.
All right. And I'm not talking on the video, I'm talking about did you see him yourself from at the gas station?
That was my answer. The way I answered it, yes.
Okay. Did you see the transaction?
With my eyes, no.
Okay. In fact, did you write your report that you did not see that transaction with your eyes?
I did not write. I do not believe I wrote a report on this deal. Investigator Bowen wrote the report.
Fair enough. After the transaction was alleged to have occurred, I think that you had testified that you went looking for Mr. Weil, is that correct?
That's correct.
All right. But the CIs wanted to go into the gas station and buy some gas, is that right?
Sort of in a, yeah.
Well,
Okay. The way it happened was the CIs pointed the defendant Weil out at basically at the center of town, walking north on North High Street. We followed him, and while we're driving, and Investigator Bowen's in the passenger side, so he can watch the video constantly, and I can see the video, but I'm also driving. We watch the defendant. We walk down to a residence on North High Street down toward White Oak School. Would be on the left side of the road as you're going. And as soon as I saw him go to the residence, we turned around and went back. The whole time you could see them on the video. They got the camera on the dope, and the doors never opened up on the truck. As a matter of fact, as I recall, Joy Debo rolled up the window on her side of the truck as right after the deal happened, as we were getting ready to do this, follow him. And then we went back to the gas station where they were still in, and then they pumped their gas and she went in to pay for it. And that's when I followed her in to the gas station, watched her twice, she paid for it, and she went out, got back in the truck, and that's when I come out, and then we followed him back to the meet location.
And then after she goes in the gas station, comes back out, then you go to a different location, and that's where you search again, is that correct?
That's correct.
Right. Anything else occur after that? with the CIs?
After we got back and searched them and took the dope and interviewed them, no.
Okay. December 8th, same process, I'm assuming. They contact you and say, we're ready to do another transaction?
That's correct.
Okay. Did you follow them again to the location?
We did, again, with me driving and Investigator Bowen in the car.
And you have a conversation with them on the way there, meaning your CIs?
Oh. Possibly, I don't recall a conversation in that particular deal.
And where is Mr. Weil's house located at?
5005 State Route 138, which is right inside of Danville on the north side of the road.
I think I heard testimony that there's like a split driveway, is that correct?
That's correct.
Can you describe, is it like a common driveway for a period and then it splits off? Is that how I understand things?
It starts out like one driveway at the end and immediately splits off to the right and goes up and makes a left up toward the residence.
Do you know how far the CIs drove up the driveway?
Not all the way. I recall there's a tree there in the front yard, and they went up by the tree and stopped right in that area. It wasn't like right up to the house.
It wasn't right up to the house?
No.
How far away from the house was it?
I couldn't tell you exactly.
You didn't drive up there yourself then?
I didn't drive up. We drove past, but I didn't drive up. No.
Okay. And do you know that they go into the house at all?
No, they did not.
No. Did Mr. Weil allegedly come out of the house? Is that how the transaction supposedly occurred?
Yes.
Okay. Anybody else come out of the house?
Not that I'm aware of.
All right. Anybody get out of the car?
No.
No.
Oh, yes, that's the one. I'm sorry. That's the one that the truck wouldn't start, and Steve Debo got out of the truck for a while, and they got it started. They had to do something to get it started, got back in the car, started back in the truck, started it up, and then they left. So it was a couple minutes after the defendant had left that they got the truck started and pulled away.
So they're in the driveway, and he's trying to start his truck, and it would not start, right?
That's correct.
Right. Did he contact you after that? To get advice from you as to what to do?
No, he got started. He come out. We did talk on the way back, but
Do you know how long it took him to get it started?
no, it was just a couple minutes. I'd say between 2 and 4 minutes in that area. Nothing long. I just know he tried to start it a couple times. He got out and you could hear him working something. Get back in and he starts it up.
Same process, they leave and they go back to
The meet location.
Yep.
That's correct.
And again, is a pat-down search of them? How do you search them?
That's pretty much on the males. It's a pat-down search. And since we don't have females available, we got a process and we go over with the CIs ahead of time that we do to make sure that they don't have dope on them prior to the deal. And we tell them ahead of time and we keep stuff in their vehicles. We make them get down to where they got one shirt on and they're whatever they happen to be wearing. And it varies depending on what they're wearing. But one thing we do, we make them, they have to take the bra off, which they all do under their shirt, or we provide them with a sweatshirt out of my vehicle to put over to get their bra off so we can see they're not hiding nothing in their bra or anything. And then they pull all their clothes tight so we can see there's nothing concealed under it. We have them roll the waistband of their pants down, whatever type of pants they got down, so we can see the top part of their underclothes, and make them pull their jeans or shorts or whatever they're wearing up tight against them so we can see anything going on.
You don't grab their private areas, but you say you're doing everything on supply, is what I'm guessing from you, is that right?
Yes, we don't, yeah. We only touch them like maybe on the lower part of the legs or on the shoulders.
Okay. December 28th, we went in sequence, so it's the last one that we're here for today.
Yes,
So, same process,
same process.
I'm going to bore the jury with the same process. I'm assuming that we've got this down by now. But I am going to ask a couple of different questions about the December 28th transaction.
Okay.
Well, maybe not different. Did they go down the same driveway?
Yes,
They go as far as they did the last time on December 8th?
about the same. I mean, I can't say exactly the same, but about the same.
Did they go into the house at all?
No,
All right. Did anybody else come out of the house?
not that I'm aware of. I've never seen anybody else or heard anybody else on the video in that deal.
Okay. That's not the transaction that a female answered the phone, that was the previous transaction.
That was the December 8th deal, yes.
Okay. And that was a smaller amount of alleged product, correct?
The 28th was a smaller amount, yes.
Okay. Why did you stop? Well, let me ask this a different way. Is that when you decided to stop investigating Mr. Weil?
It's normal that we usually set a mark. We try to do, when we first interview the people, we tell them if you're going to do somebody, we're probably going to have you do 3 deals with that person. And the reason is that if we do 3 deals with somebody, we go through this process. I mean, things can happen. Things don't always go our way. That's the way you go into 3 deals, we're going to end up with what we believe is at least 1 perfect deal, or in this case, 2 perfect deals and 1 almost.
Which one's the almost?
The 28th,
Why is it almost?
because it got dark and we couldn't see the video on the way back.
You had said that one of the precautions you take is that you take pictures of the money that you provide for the transaction. Is that correct?
That's standard procedure, yes.
Okay. You said that you do that in an instance that you have to serve a search warrant and you might be able to identify that money at a later date. Is that also correct?
That's correct.
All right. Did you serve a search warrant in this case?
No, we did not.
Is there a reason why you didn't serve a search warrant in this case?
We don't in most of our cases. We didn't. This is not something that we followed up and made a major case out of it. We generally, when we do search warrants, we're doing what we deem as major drug offenders that we believe are distributed to a number of dealers below them, who then are distributed below them.
Fair to say that Mr. Weil was never a target as a major dealer then?
Not a major, but 7 grams at a time is a substantial amount for Highland County.
Not enough for a search warrant or for you to go after the money at that time.
No, we had no probable cause to believe that he had any large amounts of dope in the house from the deals we done at that time, no.
Fair enough. Also, you had indicated that the smaller quantities led to smaller bags, which meant that you did not have to fingerprint the bags. Is that correct?
That's correct.
All right. It's again fair to say that the amounts we're talking about is not something that was substantial, or you thought that he was the higher provider?
It's fair to say we didn't believe him to be a major drug supplier of Highland County, yes.
Thank you. I have no further questions. Redirect.
Yeah. Investigator Sanders, I'll start where Mr. Borger ended. What would you consider as a major drug supplier of Highland County?
Somebody that's bringing for meth ounces of meth into Highland County.
During 2 of these deals, it was 7 grams of meth. Is that significant?
That's a 1/4 ounce. That's still a substantial amount for inside of Highland County, yes.
During the deal at the gas station on December the 5th. How long were you away from the vehicle that the CIs were in at the time that you were following the defendant away from the gas station?
2 to 3 minutes.
Gonna follow up with a question that didn't get fully developed. Gonna hand you what's previously been marked as State's Exhibit 3. You were asked who conducted the search on December the 5th. If you review that, does that indicate who conducted the search?
Yes, it does.
And what is State's Exhibit 3?
That's the surveillance report for the December 5th, 2022 deal.
And who conducted the search?
Prior to the deal, I searched both CIs and Investigator Bowen searched the vehicle. After the deal, Investigator Bowen searched both the CIs and I searched the vehicle.
Okay. And did you direct either Joy or Steve Debo to buy dope from this defendant?
No.
How did he come up?
They brought his name up and then Joy arranged the deals through Messenger.
And any other questions?
All right, can we step down?
Thank you.
Next witness.
Investigator Bowen.
All right, let's take 10 minutes then before we start again. So it's 2:10, so we'll be back at 2:20. Please.
Please rise.
All right, back on record. Next witness.
Investigator Chris Bowen.
All right, I'm reminding everybody to turn off their cell phones. Have you been sworn in?
Yes, I have.
All right, do you care to be shown or not?
I don't care.
All right, you may inquire.
Please state your name for the record.
Chris Bowen.
Are you currently employed?
Yes, I am.
And where are you employed?
At the Highland County Prosecutor's Office.
What are your job duties there at the prosecutor's office?
I work undercover at the task force.
And who do you typically work with at the task force?
We work with several agencies, Hillsborough Police Department, Greenfield, any agency in Highland County. We also work with Fayette County Sheriff's Office, Ross County Sheriff's Office, as part of the US 23 Pipeline Task Force.
How long have you been employed in law enforcement?
30 and a half years.
During your career, have you taken specialized training in illegal narcotics investigations?
I have. I've taken clandestine meth lab training, several upgraded trainings through narco conference. I've attended the narco conference in the last 2 years. Managing CIs, I've taken courses involving meth investigation management and so forth.
Have you previously worked on covert drug operations?
Yes, I have.
And what is a covert drug operation?
A covert drug operation is something we try to do secretly, not openly or public. We like to go on, we plain clothes and unmarked vehicles. We don't want it to be obvious as to what we're doing.
And do you know about how many you've worked on?
Hundreds.
And what roles have you played in these investigations?
I've worked undercover. I've worked with the CIs, controlled the money, been a control officer. I actually was a supervisor from the sheriff's office on certain deals, handle the money, surveillance logs, handle the equipment, take photographs, and look at CI phones.
Have you, have you been the one to actually participate in the hand-to-hand transaction?
I have done a few of those, yes.
Through your role as an undercover and with the task force, have you become familiar with drug words or words that we commonly see used in the drug trade?
Yes, I have.
And can you tell us, what is a ball?
A ball is 3.5 grams, and it's referring to the weight.
And what is ice?
Ice is methamphetamine.
In December of 22, were you working on undercover drug operations in Highland County?
Yes, I was.
And were you working with a CI known as Julie Hess?
Yes.
And is this her real name?
No, it is not.
And Investigator Sanders testified that, did you go over the CI procedures with the CI with Investigator Sanders?
Yes, I did.
And did she advise that she could purchase meth from Stephen Weil?
That's correct.
Do you see the person you know as Stephen Weil in the courtroom today?
Yes, I do.
And can you point him out for the court?
He's seated right here in a black vest with a blue shirt and tie.
And when was the last time that you saw the defendant?
December 8th, 2022.
And is there something or anything different about him now as the last time you saw him?
Yes, he has a tattoo on his face now.
I'm going to talk about December the 5th. Did you and Investigator Sanders conduct an undercover buy with the defendant, the deal that's been referred to as the cruiser deal?
Yes.
Approach the witness.
Okay.
Getting into it's previously been marked as State's Exhibit 6 for identification purposes. Do you recognize that?
Yes, this is a photograph that I took from Joy Debo's cell phone after the deal. It's phone contact for Stephen Weil and Joy Debo's phone.
And State's Exhibit 7. Do you recognize that?
Yes, this is another photograph from Joy Debo's phone, messages between the two of them setting up the deal.
State's Exhibit 8.
Yes, this is another photograph that I took after the deal from Joy Debo's cell phone.
State's Exhibit 9.
That's another photograph that I took from Joy Debo's phone.
And State's Exhibit 10.
Again, it's another photograph that I took from Joy Debo's phone after the deal.
State's Exhibit 11.
Another photograph that I took from Joy Debo's phone after the deal.
States Exhibit 12.
Another photograph of another message from Joy Debo's phone that I took after the deal.
States Exhibit 13.
Another photograph that I took from Joy Debo's phone after the deal.
States Exhibit 14.
Another photograph that I took from Joy Debo's phone after the deal.
States Exhibit 15.
Again, another photograph from Joy Debo's phone.
16.
Another photograph that I took from Joy Debo's phone after the deal.
And finally 17.
Another photograph that I took from Joy Debo's phone after the deal.
Now, based on those messages between the CI and the defendant, where was the deal set up to take place?
At the Marathon gas station located in Morristown. The address to that location is 5 East Main Street in Morristown.
And what county is that in?
That's in Highland County and in White Oak Township.
I'm going to show you what's previously been marked as States Exhibit 20 for identification purposes. Do you recognize this?
Yes, this is a certified copy of the map from the auditor's office showing the distance from the gas station to the school property, which is 825 feet. That's within 1,000 feet.
Is that the high school property there in Morristown?
Yes, it is.
I'm next going to hand you what's previously been marked as States Exhibit 2 for identification. I'm sorry, States Exhibit 3 for identification purposes. Do you recognize that?
Yes, this is the surveillance report that we do on every deal. This is for December 5th, 2022.
And was that report completed in real time as the deal was taking place and kept as part of your work with the task force?
Yes, it was.
Now, according to the report and based on the testimony of Investigator Sanders, were all the deal procedures followed in searching the CIs in their vehicle?
Yes, they were.
Did you provide the CI with an audio and video recorder?
Yes, I did.
I'm next going to hand you what's previously been marked as States Exhibit 4 for identification purposes. Do you recognize this?
Yes, this is a receipt. It's a cash expenditure voucher. Shows how much money we paid for the dope and what we actually paid the CI after the deal. And this was on December 5th, 2022.
I'm next going to hand you what's previously been marked as States Exhibit 5 for identification purposes. Do you recognize that?
Yes, this is a photograph of the $120 used for the purchase of the drugs on December 5th.
Next, I'm going to show you what's previously been marked as States Exhibit 18 for identification purposes. Do you recognize that?
Yes, this is a video from the deal on December 5th, 2022.
And do you know who we're going to see on this video?
We're going to see Joy Debo and the defendant, Stephen Will, on the video.
Now, is this the video of the entire transaction from the moment the CIs were searched to the very end, or is it a shortened section?
It's a shortened partial section showing the deal itself.
Is it a true and accurate copy of the section showing the deal itself on December 5th of 22?
Yes, it is.
At this time, we would move to admit and publish States Exhibit 18.
Any objection?
No objection?
It's admitted and may be published.
Yeah, did you get that? That's right. You done? Oh, okay. You want to get gas, you need to go meet somewhere. He's walking right there, he went straight ahead, where you're at. He's walking. Yeah. He's got a brown leather coat on, carrying a carton of smokes. Yeah, that one. And a hat. Let me just get gas here, and what we want me to do. I don't know, my gas gauge don't work, but we'll take a chance. Okay, yeah, you're right. Okay. All right. Okay. I'll get the phone. Sorry, man. You can just say where they can see it. You know, it's complicated. Yeah, you just already outside, walk around to the truck.
I'm going to hand you what's previously remarked as State's Exhibit 19 for identification purposes. Do you recognize that?
Yes, this is a photograph that I took from the video. After a deal's done, I will take the video back to either the prosecutor's office. I'll view it, I'll watch it, I can stop it and freeze it, and that's when I take a photograph. This is a photograph of Mr. Will standing outside the passenger door of the Debo vehicle in Morristown.
I'm next going to hand you what's previously remarked as State's Exhibit 2 for identification purposes. Do you recognize that?
Yes, this is the evidence that I collected from the orange vest after the deal. At the debrief, I then took this evidence and secured it at the Hillsborough Police Department, and I secured it in evidence locker number 9 at the Hillsborough Police Department.
Now, we saw in the video that the video was placed to see that the meth in the vehicle, did it remain there until you met back up with them?
Yes, it did.
On December the 8th of 22, did you and Investigator Sanders again work with the same CI to conduct an undercover buy with the defendant?
Yes.
This is the deal that's been referred to as the deal where the truck broke down?
Yes.
I'm going to hand you what's previously been marked as State's Exhibit 26 for identification purposes. Do you recognize this?
Yes, this is a photograph that I took on December 8th after the deal of the contact and Joy Debo's cell phone.
And states Exhibit 27.
This would also be another photograph from Joy Debo's cell phone that I took after the deal on December 8th.
28.
Another photograph that I took from Joy Debo's phone after the deal.
29.
Another message and photograph that I took after the deal on December 8th.
And 30.
Same thing, another photograph that I took from Joy Debo's phone.
And based on the messages between the CI and the defendant, where was the deal set to take place?
At Stephen Will's residence on 138.
I'm going to hand you what's previously been marked as State's Exhibit 34 for identification purposes. Do you recognize that?
Yeah, this is a warranty deed for the property from the Highland County Map Office, certified copy. It shows the address of 5005 Stair Island 38 Hillsborough, and the owner is Stephen Will.
I'm handing you what's previously been marked as State's Exhibit 23 for identification purposes. Do you recognize that?
Yeah, this is the surveillance report that I kept for December 8, 2022 during the deal.
And is that a report that's completed in real time as the deal is taking place and kept as part of your records with the task force?
It is.
And again, prior to the deal, were the deal procedures followed, the sort of procedures followed that investigator Sanders testified about earlier?
Yes, it was.
And did you provide the CIs with an audio and video recorder?
Yes, I did.
Handing you what's previously been marked as State's Exhibit 24 for identification purposes. Do you recognize this?
Yes, this is the receipt where it shows we paid $120 for the dope that we purchased on December 8th, and also shows a receipt where we paid Joy Debo $50.
State's Exhibit 25. Do you recognize this?
Yes, this is a photograph that I took of the $120 to purchase the drugs with on December 8th.
Next, going to hand you what's previously been marked as State's Exhibit 31 for identification purposes. Do you recognize this?
Yes, this is the video from December 8th, 2022.
And who are we going to see in here on this video?
You're going to see Joy Debo and Stephen Will in the video.
And is it a true and accurate, or I'm sorry, let me back up. Is this a video of the entire time from the second that they were searched to the very end, or is it a shorter portion of the video?
It's a partial video again.
And is it a true and accurate copy of the portion of the deal on December 8th of 22?
Yes, it is.
This time I would move to admit and publish State's Exhibit 31 for the jury.
Objection.
No objection.
Submitted, may be published.
How do you drive that?
Yes, this is a photograph I took from the video. Depicts Stephen Will standing outside the passenger door of the depot vehicle.
And State's Exhibit 33, do you recognize that?
Yes, this is another photograph of Mr. Will standing outside the depot's vehicle after the deal. It looks like he's got the money in his hand.
Next, I'm going to hand you what's previously been marked as State's Exhibit 22 for identification purposes. Do you recognize that?
Yes, this is the evidence that I collected from the depot vehicle after the deal. At our debrief location, I collected this off of the orange vest, as you've seen in the video.
So that's what was shown in the video.
Yes.
And was the camera placed on that and kept on that during the entire time until they met with you again?
Yes, it was.
Our State's Exhibit. I hand you State's Exhibits 4, 24, and 45. Can you tell me how much Joy Devo is paid for her work in this case?
Yes, $170.
Our State's Exhibits 5 through 17, 19, 25 through 30, 32, and 33, which were all pictures, true and accurate depictions of the scene as they appeared on December 5th and 8th, 2022.
Yes.
I have no further questions.
Ross?
Thank you, Your Honor. Good afternoon, Mr. Bowen.
Good afternoon.
Let's take each of these separately, as we have been doing all day. Then you've actually, as the complainant witness, you've been able to see and hear all the testimony, correct?
That's correct.
Okay. And so, for December 5th, we went through the process of the search prior to them going to the gas station and in your CIs.
Correct.
We talked about the search of their persons. In the video, we saw a purse that was also on Ms. Devo. Did you search that?
Yes, we search their purses, we search anything that's inside the vehicle. When we do a vehicle search, we check between the seats and the console, the glove compartment under the seats, and we search their person thoroughly as well.
When would you have searched the purse? At the meat place before?
The purse would have been searched at the beginning of the deal and after the deal.
All right. And the purse, would you have emptied the contents or would it have just been a search? And did you conduct that search? Sorry, multiple questions. Let me ask one. Did you conduct the search of the purse?
Without looking at my surveillance report, I really couldn't answer that. I don't know if I searched it before or after or both times. I wouldn't know that without looking at the surveillance report.
Okay. Assuming that you would have been the one to search, would you have emptied the contents out and put it back in?
If there's a bunch of stuff in it, yes, I would, but if there's not a lot, I just kind of go through it with my hand. If there's containers inside the purse, I would open them, such as a wallet and things of that nature.
Did you recall anything of that nature?
I don't recall.
Okay. Saw that the purse, though, was located in the video right by your feet. Is that right?
Yes.
Okay. No concerns about that?
No, sir.
Okay. May I approach?
You may.
Got a question about the map, and I want to make sure I'm clear on this.
Okay.
I'm using a term that probably the younger people in the jury don't understand. This right here, where are we? What is this?
That's the gas station.
And this right here, what is this?
That is the Bright Local School District property.
All right, and the property line actually goes all the way around.
Yes, it does. That's correct.
And so the measurement is how much?
825 feet.
All right, and the old term I was referring to is it's as the crow flies, essentially, correct?
Correct.
All right, not down street, not down here, not to the school, but to the school property was 825 feet.
That's correct.
And also not necessarily where Stephen Weil was alleged to be. It's about how close it is in proximity to the gas station itself, right?
That's correct.
All right, I just want to make sure it's clear for the jury. Transaction on December the 5th was pretty quick. Would you agree?
I would agree.
All right. Did you see it with your own eyes?
Yes, I watched the video. I did not see it with my own eyes. I'm monitoring the video live stream.
All right. And you were with Mr. Sanders, correct?
That's correct.
Okay. For the December 8th transaction, you followed them, meaning your CIs to, well, actually, let me back up. December 5th. We also heard Ms. Debo talk to Mr. Weil, or who's purported to be Mr. Weil, correct?
Correct.
All right. And Ms. Debo said, I'm going to tell somebody hello. Did you hear that?
Yes.
All right. Do you know who she said that she's going to say, I'm going to tell her hello?
From my understanding of what I heard, she was going to tell one of her kids hello, that Mr. Weil had a crush on one of her kids at one point or another. That's the way I took from it.
All right. But you just heard her testify earlier today that she really had no idea who Mr. Weil was until 4 months prior. Did you hear that?
Yes, I did.
Is that consistent with that conversation?
Objection, that's a decision for the jury to make.
Correct. I'll sustain that.
Withdrawn. December 8th, you were following them to the property, correct?
I was riding in a vehicle that was following them to a property, yes, sir.
Okay. And when did you surveil them going into the property, or were you just seeing it on video?
I'm seeing it on video, and I'm keeping a log of the deal during that time, which is on the surveillance report.
Okay. I'm also going to point out one thing that was stated on that video as well for December 8th.
I'm sorry, I was distracted. Can you repeat that? I apologize.
No problem. I'm going to point out something that was stated on that video that was purported to be stated by Mr. Weil at that point there. Do you recall, or did you see where he said he just moved back into his house the night before?
I'm not sure what you're referring to.
Okay. Mr. Wills purported to come out to the window,
Okay, yes, sir.
and Ms. Debo's at the window,
Yes,
right? She rolls it down.
yes.
She said something about his kids. Is that right?
On the 8th deal, yes.
Yeah. And did you hear Mr. Weil say, I just moved back here yesterday?
I did not hear that, no, sir.
Okay. I'll move on. Give me just one moment, Your Honor.
All right?
Okay.
No further questions, thank you.
Redirect?
Then you're on.
All right, you may step down. You have any other witnesses? All right, ladies and gentlemen, we're going to take a break now. It's 3 o'clock. The eclipse is supposed to be at its maximum at 3:15. So I'm going to ask or give you until 3:25 or so, and we're going to do a couple of other things business-wise while you're out there. If you want to go outside and watch the eclipse, you may go ahead and exit out either door, or if you want to just stay in the jury room, you can do that. If you do, we need to shut the door because proceedings on taking place have to be outside your presence. It's a legal matter. So at this time, we'll stand in recess until 3:20. Counsel, if you just remain, please.
Please rise.
Go ahead. I'm just stretching my legs. So.
I don't know.
All right, we're back on record, outside the presence of the jury. One thing I didn't get in the record, I want to read in the record, or I'll tell the jury afterward, but I do have a stipulation about the school, and I'll read that to them, and then I have the stipulation of chain of custody. I'm not going to read it to them, I'll give maybe a real quick summary. And so that's my stipulation. I just want to put that on the record. Is that correct, counsel?
That is correct, Your Honor.
Yes, Your Honor.
All right. And then the other thing is the video may show that I sent a note to the bailiff to show to Mr. King. I was trying to get less downtime between the exhibits, and that's what it was. It said, see if you can have it ready to go. But then I see what happened is that she marked it first and then continued to ask questions. So, yeah, anyway, that's why I did that. I just want that to be explained, so it's what it was that I sent over, so if it shows on video. All right, now, you've rested. You wish to admit your exhibits?
Yes, we would move to admit State's Exhibits 1 through 47, with the exception of number 35, which was nothing.
Right. Any objections to any exhibits, Mr. Organ?
No, Your Honor.
All right. We'll be all admit. All right.
I have no basis for objection.
Thank you. All right. And you wish to make a Rule 29?
I do.
All right. You wish to argue or submit it?
Pardon?
You wish to argue or submit it?
I want to have a little bit of argument.
All right. Go ahead.
What's that? Oh, Rule 29?
On Rule 29.
I'll submit on that. Sorry.
Oh, okay. All right. Gotcha. All right. Then the court will deny that because the evidence is such it's a question of the prior fact, making a decision as to the sufficiency of the evidence. And, all right. Now, are you going to put on any evidence?
No, Your Honor.
All right. Then want to renew your motion?
We'll renew the motion.
Okay.
Rule 29.
All right. The court will deny that. All right. Okay. Now, then the next question would be the jury instructions. And I did make all the changes to the verdict forms. And I did note, and I don't know if you guys noted it later, but actually on the numerical designation on the trafficking, it was A2, and I changed it to A1. Mm-hmm. And I made the same changes all through consistent.
Mr. King found several.
I've already corrected those, I think. The verdict forms are all done.
Well, in count 1, did you change the verdict form to be aggravated trafficking in meth instead of in drugs?
Yeah.
And then Stephen's name is spelled wrong. It's back and forth each, not just in the title, but down here as well.
Oh, it's PH, isn't it? All right, I'll have to go change that. I never even noticed that.
I think you fixed
Okay.
that.
All right, well, I'll make that change.
And then the drugs thing is clear throughout.
I'm sorry?
Where it says trafficking in drugs instead
Yeah.
of trafficking in meth.
Yeah.
It's also in count 3.
I went through all those forms during lunch hour. And other than the spelling of his first name, I believe I caught everything else.
Okay. All right.
Now, on the instructions, anything?
Page, this is kind of picky, but in determining its weight, it's under the expert testimony. You may take into consideration his skill, experience. We only had female experts today.
Yeah, I normally have his, her, but I think this may have been an older set of instructions. I'll make that change. What page?
That was page 3.
Okay.
In every one of these, I just noticed this is different than how you usually do it. How determined is usually under knowingly?
Yes.
And
Suppose
it's-
it'd be there. Where's it out of order somewhere?
Yeah, it's
What
under
page?
motive, page 6.
Page 6, all right. How determined, yeah, that should be under knowingly.
So it's also like that one.
It'll be consistent because I believe I replicated that, cut and pasted on everyone, so.
Well, it's not like that under the possessions, only the trafficking.
Oh, okay, well, that was a different cut and paste, yeah. Yeah.
Okay, page 24. Into determining whether or not the is subject to forfeiture.
Should be real estate.
And then the whole last sentence there under that forfeiture part, if the weight of the evidence is equally balanced, or if you were unable to determine which of the parties has the preponderance, it's just weird to me. I know what you mean, but it sounds strange. And then it's not
That's
a
the instruction. What it is the preponderance is that it's just slightly more, and if it's equal, then they haven't proven it.
I know, but when
That's
you,
a standard
I'm just
civil.
saying when you read it, it doesn't read well. But it's not a tow truck.
Well, I'm not asking for stylistic changes, just,
It's
you know,
just
corrections
confusing.
or
And
errors.
it's also not a tow truck, it's real estate.
Yes, that's from the top. And which page is that on?
The same, right in the same sentence.
Okay, all right. All right.
Okay, page 28. They don't find him guilty of the forfeiture, I don't believe.
On page 28, what?
Count 6 on page 28. He said if you find the defendant not guilty of both counts 3 and 5, then your verdict on count 6 must be not guilty, but
Correct.
they don't find him guilty of a forfeiture.
Yeah, they do. I mean, well, they don't, that's true. All right, I'll change the wording to you must find against the forfeiture. Yeah, okay, I think that's reasonable.
That's all I found.
All right. Mr. Borger, anything?
No, I had noticed the tow truck as well, which
Right,
is
okay.
not an issue now.
Right.
But the rest of the changes, I believe, are fine, and I don't see anything else.
Okay. Any other requests for instructions from either side, Ms. Collins and Mr. Borger?
No, Your Honor.
All right, let me go back and make those changes, and then we'll go right to argument. And I'm going to, what I do is I will give them the instructions first on the substantive law, then argument, and then the verdict instructions on how to deliberate. Okay? So we'll, yeah, we got about 12 minutes, 13 minutes here. The jury is back. Looks like the eclipse is passing, so everything's running according to plan, I guess. So during the break, ladies and gentlemen, we did a number of legal matters, and the state rested, and we are now going to proceed with the instructions from the court. You'll then hear the closing arguments from the attorneys, and then at the conclusion of that, I will instruct you on how to deliberate and return verdicts. Now, ladies and gentlemen, you've heard the evidence. It's the duty of the court to now instruct you on the matters of law. Court and the jury have separate functions. You decide the disputed facts. The court provides the instructions of law. Now, it's your sworn duty, ladies and gentlemen, to accept these instructions and to apply the law as it is given to you. You're not permitted to change the law or to apply your own conception of what you think the law should be. All criminal cases begin with filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. Defendant entered a plea of guilty, of not guilty, which is a denial of the charges and puts in issue all the essential elements of the offenses. Defendant is presumed innocent until his guilt is established beyond a reasonable doubt. Defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Now, reasonable doubt is present when jurors, after they have carefully considered and compared all the evidence, cannot say that they are firmly convinced of the truth of the charge. It's a doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You'll apply the test of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand, their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. Now, you're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will decide what testimony is worthy of belief and what testimony is not worthy of belief. Now, each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. And during the trial, counsel was able to inquire into some matters that did not directly relate to the issues before the court. Such questions and answers are permitted for the purpose of helping you determine the credibility and the weight to be given to the testimony and for no other purpose. Now, it is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not be considered for any purpose. Now, generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may help you to provide to help you to arrive at a just verdict. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the experts. In determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. Now, you may have observed during the course of this trial that the defendant's in the custody of the sheriff's office. This is not an indication of his guilt or innocence. It simply means that he has not been able to post the bail that the court required during the pendency of this action. And you may not consider the fact that he is in custody for any purpose. Now, ladies and gentlemen, evidence is all the testimony that was received from the witnesses, thank you, and any exhibits that the court has admitted into evidence during the trial. Evidence may be direct, or may be circumstantial, or it may be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which they testify. And it includes also exhibits admitted in evidence during the trial. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from the other facts which you have found have been established by direct evidence. Whether inference is made rests entirely with you. Now, when considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. So, in other words, you can't stack one inference upon another inference to reach a factual conclusion. Where the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence and convinces you beyond a reasonable doubt that the defendant is guilty. Now, the evidence does not include the indictment, the opening statements, or closing arguments of counsel. Opening statements and closing arguments, as I've indicated to you previously, are designed to assist you, but they are not evidence. Any statements that were stricken by the court that you were told to disregard are not evidence and must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been. You must not draw any inference or speculate on the truth of any suggestion that might be included in a question that was not answered. Now, a number of exhibits have been introduced, and testimony relating to them has been introduced and admitted into evidence. And you may consider whether the exhibits are the same objects in the same conditions they were originally, and you'll determine what weight, if any, you should give to the exhibits. All right, now, the law under which the defendant is charged in count 1, and 3 and 5, I'm going to recount 1 for now. The law under which the defendant is charged in count 1 is entitled Aggravated Trafficking of Methamphetamine, and is numbered Revised Code Section 2925.03A1. And this law states in pertinent part as follows: no person shall knowingly sell or offer to sell a Schedule II controlled substance in violation of Section 2925.03A1 of the Revised Code. So before you can find the defendant guilty, as to count 1, you must find beyond a reasonable doubt that on or about December 5, 2022 in Highland County, Ohio, the defendant did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance. Shall knowingly sell or offer to sell a Schedule II controlled substance in violation of Section 2925.03A1 of the Revised Code. So before you can find the defendant, technology. There we go. It just did it on itself. There's no way I can affect that from here. I don't know. Gremlins. All right. So, the essential elements of the crime of aggravated trafficking of methamphetamine as charged in count 1 of the indictment are as follows: that the defendant did 1, knowingly; 2, sell or offer to sell; 3, methamphetamine, a Schedule II controlled substance; and 4, the offense occurred in Highland County on or about the date alleged in the indictment. Now, as to time, it's not necessary the state prove the offense was committed on the exact day as charged in the indictment. It's sufficient to prove the offense took place on a date reasonably near the date claimed. Now, before you can decide whether the state has proved beyond a reasonable doubt all of the essential elements of the offense in count 1 with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held, this is called venue. And the state must prove beyond a reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Now, knowingly. A person acts knowingly regardless of his purpose when he is aware that his conduct will probably cause a certain result, or is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You'll determine from the facts and circumstances whether there existed in the time in the mind of the defendant an awareness of the probability the defendant's actions will cause a certain result or be of a certain nature. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge, where an act is a crime, a good motive, or a purpose is not a defense. Now, controlled substance. Various chemical compounds subject to government control are called controlled substances and are placed into various categories or schedules by the Ohio Revised Code. Methamphetamine is a Schedule II controlled substance. Sale includes delivery, barter, exchange, transfer, or gift, or offer thereof, and each such transaction made by any person, whether as principal, proprietor, agent, servant, or employee. Offer means present for acceptance or rejection. So if you find that the state proved beyond a reasonable doubt all of the essential elements of the offense charged in count 1 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 1 of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, in regards to count 1, if you find the defendant guilty of the offense charged in count 1, then you will make additional findings beyond a reasonable doubt as to the amount of the methamphetamine that was involved. You'll determine whether the amount involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. If your finding is not guilty, you'll not make any finding on this issue. And under the revised code, section 2925.01, bulk amount of methamphetamine is 3 grams. Now, if your verdict is guilty of count 1 of the indictment, you'll then separately decide beyond a reasonable doubt if the defendant committed the offense in the vicinity of the school zone. If your verdict is not guilty, you will not decide this issue. An offense is committed in the vicinity of a school if the offender commits the offense on school premises in a school building or within 1,000 feet of the boundaries of any school premises, regardless of whether the offender knows the offense is being committed on school premises, in a school building, or within 1,000 feet of the boundaries of any school premises. Now, school means any school operated by a Board of Education, any community school established under Chapter 3314 of the Revised Code, or any non-public school for which the Director of Education and Workforce prescribes minimum standards under Section 3301.07 of the Revised Code, whether or not any instruction, extracurricular activities, or training provided by the school is being conducted at the time a criminal offense is committed. And I'll instruct you that the parties did enter into a stipulation that Bright Local High School is a school operating under the Ohio Board of Education approved curriculum is required to be a school zone, and that Bright Local was in operation during the period of December 1 through December 31, 2022. School premises means any of the following: the parcel of real property in which the school is situated, whether or not any instruction, extracurricular activities, or training provided by the school is being conducted on the premises at the time a criminal offense is committed, or any other parcel of real property that is owned or leased by a Board of Education of a school, the governing authority of a community school, established under Chapter 3314 of the Revised Code, or the governing body of a non-public school for which the Director of Education and Workforce prescribes minimum standards under Section 3301.07 of the Revised Code, and on which some of the instruction, extracurricular activities, or training of the school is conducted, whether or not any instruction, extracurricular activities, or training provided by the school is being conducted on the parcel of real property at the time the criminal offense is committed. And school building means any building in which any of the instruction, extracurricular activities, or training provided by a school is conducted, whether or not any instruction, extracurricular activities, or training provided by the school is being conducted in the school building at the time the criminal offense is committed. So that's the law on count 1. Now, count 2 is aggravated possession, and it's 2 and 4. Counts 2 and 4 are both aggravated possession of methamphetamine. And the law under which the defendant is charged in count 2 is entitled aggravated possession of methamphetamine, and is numbered Revised Code Section 2925.11. And this law states in pertinent part as follows: no person shall knowingly obtain, possess, or use a Schedule A controlled substance. The defendant is charged in count 2 with aggravated possession of methamphetamine under that section. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about December 5, 2022, in Highland County, Ohio, the defendant knowingly obtained, possessed, or used methamphetamine, a Schedule II controlled substance. So there are 4 essential elements of count 2. The essential elements of the crime of aggravated possession of methamphetamine as charged in the indictment in count 2 are as follows: the defendant did 1, knowingly; 2, obtain, possess, or use; 3, methamphetamine, a Schedule II controlled substance; and 4, that the offense occurred in Highland County on or about the date alleged. So you can probably tell that the difference between counts 1 and 2 is count 1 obviously was a knowingly selling or offer to sell, whereas count 2 is obtaining, possessing, or using instead of selling. And the reason I say that is because the definitions I gave you on count 1 are the same, and I'm not going to reread all of them. But I instructed you about time, venue, knowingly, how determined, motive, all of those things apply in this case, in this count as well. Possession of methamphetamine is an essential element of the offense of aggravated possession of methamphetamine. Possess or possession means having a control over a thing or substance that may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises on which the thing or substance is found. Possession is a voluntary act. If the possessor knowingly procured or received the item or is aware of his control thereof for a sufficient period of time to have ended his possession. A person has possession when he knows that he has the object on or about his person or places it where it's accessible to his use or direction, and he has the ability to direct or control its use. Possession may be constructive. Constructive possession exists when an individual is able to exercise dominion or control over an item, even if the individual does not have the item within his immediate control. And dominion or control may be established by circumstantial evidence alone. To find that an individual constructively possessed an item, the evidence must also demonstrate the individual was conscious of the presence of the object, although a defendant's mere proximity in itself is not sufficient to establish constructive possession. Proximity to the object may constitute some evidence of constructive possession. Thus, the presence of the individual in the vicinity of the item, coupled with other facts probative of dominion and control, may establish constructive possession. Two or more persons may have possession if together they have the ability to control it, exclusive of others. Ownership is not necessary. A person may possess or control property belonging to another. And also, again, methamphetamine is a Schedule II controlled substance, as I instructed you in count 1. So if you find the state proved beyond a reasonable doubt all the essential elements of the offense of charge in count 2 of the indictment, then your verdict must be guilty according to such offense and your findings. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 2 of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, with regard to count 2, there is just one additional finding, and that is, again, the bulk amount. If you find the defendant guilty, you'll make the additional finding as to the amount involved, whether it was equal to or exceeding bulk, but less than 5 times bulk. And again, if your finding is not guilty, you don't make that finding. And the same instruction, bulk amount is 3 grams. Now, the law under count 3 is the same as count 1. It's aggravated trafficking, and it's the same offense and alleges the same conduct, except that it occurred on or about, allegedly occurred on or about December 8, 2022, at which time it's alleged that he knowingly did sell or offer to sell methamphetamine, a Schedule II controlled substance. So the essential elements of count 1 that I explained to you earlier, knowingly selling or offering to sell methamphetamine, and the offense occurred in Highland County venue, all of the instructions I gave you on count 1 are identical here. Now, in the event that you find the defendant guilty of count 3, then you make one additional finding, and that is, again, whether the amount involved was equal to or exceeding the bulk amount, but less than 5 times the bulk amount. Count 4 is aggravated possession. It's the same as count 2, and the same instructions I gave you, except that the date alleged, again, is December 8, 2022. And so 1 and 2 apply December 5, or have a date of December 5. 3 and 4 have the date of December 8, 2022, both of them. All right, and the essential elements of aggravated possession, again, are the same as I instructed you on count 2, and you'll apply those definitions. Now, count 5, again, in count 4, if you find the defendant guilty, then again, you'll make the additional finding as to whether the amount involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. And if your finding is not guilty, you'll make no findings on that issue. And again, as to both counts 3 and 4, if you find that the state proved beyond reasonable doubt all the essential elements of those offenses, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond reasonable doubt any of the essential elements of either count 3 or 4, then your verdict must be not guilty as to such offense according to your findings. All right, now count 5 is also aggravated trafficking of methamphetamine. It's identical to count 1 and 3, except that the date alleged is December 28. Otherwise, all the essential elements and the definitions applying to those that I gave you as to count 1 apply to count 5. as they do count 3. And the only difference is in count 5, you don't make any additional findings if you find the defendant guilty. So if you find that the state proved beyond a reasonable doubt all the essential elements of the offense charged in count 5, then your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 5, your verdict must be not guilty as to such offense according to your findings. Now, count 6 is a specification. And if you have found the defendant guilty as to counts 3 and or 5, which are alleged trafficking, aggravated trafficking on December 8 or December 28, 2022, then you'll determine whether or not the specification charge in count 6 of the indictment has been proven by the state. So if you find the defendant guilty, you'll then deliberate and make a finding as to whether the defendant owes real estate that's subject to criminal forfeiture. The state claims the defendant's right, title, and real estate located at 5005 SR 138, Hillsborough, Highland County, parcel number 20-19-100-038.00, is subject to forfeiture. If you find by the greater weight of the evidence that the real estate was used in any manner to commit or to facilitate or to aid in the commission of the offense of aggravated trafficking of methamphetamine on December 5 and or December 8, 2023, as charged in counts 3 and 5, the property is subject to forfeiture. The burden of proof on forfeiture upon the state with regard to a specification is by a preponderance of the evidence, not beyond a reasonable doubt, which is a burden the state must prove the defendant is guilty of the offenses of aggravated trafficking charged in counts 3 and 5, and actually all of the criminal offenses of 1 through 5. So preponderance of the evidence is the greater weight of the evidence. That is evidence that you believe because it outweighs or overbalances in your mind the evidence opposed to it. Preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. Quality may or may not be identical with quantity or the greater number of witnesses. In determining whether or not the real estate is subject to forfeiture and that has been proven by preponderance of evidence, you should consider all the evidence bearing upon that issue regardless of who produced it. If the evidence of the weight of the evidence is equally balanced, or if you're unable to determine which of the parties has the preponderance, then the state has not proven that the real estate is subject to forfeiture. All right, now, the charges set forth in each count of the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately. You must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged in counts 1 through 5. Count 6 is a forfeiture. So that is the law on the that is applicable here, and it sounds like a lot, and it is. And I want to tell you now, you will have copies of these instructions. I do have to make a couple of corrections on some typos and cut and paste errors I made, which I always find some when I'm reading them, even though I've read them probably 5 times before I read them for the last time. But I'll make those changes and I'll go in there to you so that when you do deliberate, if you have questions about the law, it's going to be there for you. You don't have to try to memorize it. I know I can't. I don't even try to memorize it. That's why I read it, because even though I've been in this business 48 years, and I know some judges who try to give this from memory, you know, if you leave something out, it's not good. So I don't try to even begin to memorize it. That's why I read it. All right. Now, at this time, we're going to hear the closing arguments. Closing arguments are not evidence. They are simply the attorney's beliefs and arguments as to what they think the evidence has or hasn't shown. But they're not considered to be evidence. Now, because the state has the burden of proof, they have the right to go first and then also to rebut after the defendant's argument. And so at this time, Mrs. Collins, on behalf of the state.
May it please the court, Mr. Borger, ladies and gentlemen of the jury, I first want to thank you for your time and attention to this very detailed case today. So we are one of the few countries that uses a jury system to decide guilt, and that only works with citizens like yourselves who take their service seriously, and for that I want to say thank you. Now, as the court said, I do have 2 opportunities to address you, so I will keep this first closing short and to the point. In the fall of 2022, investigators Randy Sanders and Chris Bowen met with Steve and Joy Debo. Both wanted to work with investigators Sanders and Bowen, and they were willing to use them as CIs or undercover civilians. Investigator Sanders went over the process of buying meth with both of them, and then Joy and Steve told investigator Sanders and Bowen the names of people that they could buy meth from. On December 5th of 2022, Joy made contact with Stephen Weil and told Weil that she needed an 8-ball of meth. This is the deal that occurred at the gas station in Morristown, and it's the deal that we referred to as the cruiser deal, because on the way to the deal, a sheriff's cruiser gets behind the CIs and they have to turn off to get away from him and all that. The defendant advised Joy in a text message that he had an 8-ball available, and the deal at the gas station in Morristown was arranged. Steve Debo drove his wife Joy to the Marathon gas station at 5 East Main Street in Morristown in Highland County, Ohio. Weil walked up to the passenger side of the truck, and Joy handed him $120 in cash. Weil handed her a bag of meth weighing 6.90 grams, just shy of the 2 8-balls that she ordered. And you know this as being identified as State's Exhibit 2 today during the trial. The Marathon gas station is less than 1,000 feet from what has been stipulated to be Bright Local High School, and you can see that in State's Exhibit 20, which shows the high school and shows the high school here and the Marathon gas station here, and this is 825 feet. Stephen Weil sold methamphetamine in an amount equal to or exceeding bulk, equal to or exceeding 3 grams in the vicinity of a school zone on December the 5th, 2022. On December 8th, Joy again made contact with Stephen Weil and again asked if he had 2 8-balls or 7 grams of meth available to sell. This is the deal that occurred at his house where the truck won't start at the end of the deal and they have to spray it with ether to get the truck running again. Again, Steve Debo, again, this deal was arranged via text messages back and forth between Joy and the defendant. Steve Debo drove Joy to Weil's house at 5005 State Route 138 in Danville and Highland County. Weil came out of his house to the passenger side of the truck. Joy handed Weil $120, and Weil handed Joy a bag of methamphetamine weighing 7.38 grams. So again, this one was just over the 2 8-balls that Joy had ordered, and you will know this as State's Exhibit 22. It's been identified as State's Exhibit 22 today during the testimony. On December 28th, 2022, Joy again made contact with Stephen Weil and asked if he had 2.5 grams of meth available, and he told her he had 2.5 grams of meth available. Will advised he had the meth, and the second deal at his house was arranged. Again, Steve Debo drove Joy to Weil's house at 5005 State Route 138 in Danville and Highland County. Will came out of his house to the passenger side of the truck. And this is the deal that we referred to as a cigarette deal because she gives him the money, and then she also gives him what's left in a pack of cigarettes. He had asked her in the text messages, when you come, can you stop and get me some cigarettes too? So she hands him $50 and what's left of the pack of cigarettes she has, and he hands her a bag of meth weighing 2.57 grams, which was identified today as State's Exhibit 47. Again, Will sold methamphetamine from his home on December the 28th, 2022. Ladies and gentlemen, there is no question that Stephen Weil supplied methamphetamine to Joy Debo, and Steve Debo was driving the vehicle when this happened. Stephen Weil is guilty of trafficking or selling methamphetamine. Obviously, to sell it, he was possessing it. He had it in his hand when he handed it to Joy. Thank you.
All right, thank you, Ms. Borger. On behalf of the defendant.
Thank you, Your Honor. May it please the court, Prosecutor Collins and King. First and foremost, ladies and gentlemen, thank you for your time today. As the prosecutor indicated, this is one of the most significant duties a citizen can do, and I appreciate your time today, especially as we saw the eclipse as well. Judge has given you instructions, and you're going to deliberate in just a minute. And couple things that I want to point out to you with respect to what we have heard today. And I'm going to take each one of these days separately, just as the prosecutor did. December 5th. First, we had testimony from Ms. Debo, who said she had only one previous contact with Mr. Weil prior to that transaction, or them texting each other. But clearly that's not believable, especially after you saw the video with what was purported to be Mr. Weil and her exchanging information about her saying she would say hello to her daughter. So if she's lying about that, what else is she lying about? You saw the purse next to her at the gas station. We heard testimony about how they conducted searches, but the search was not all-inclusive. It was substantial according to law enforcement. It was substantial according to the confidential informants. But obviously, they all have a vested interest in making sure that that's the testimony that they provided. The simple fact of the matter is, the transaction occurred so quickly that there was no real sight of any product being given to Ms. Debo. The December 8th. For one, I want to point out to you that the video said, or my client allegedly said in the video, that he just moved back to that house that day. Significant for count 6, and I'll just leave it at that. With respect to that as well, there was some issues that were associated with that stop or with that transaction as well. The car broke down. Mr. Debo gets out of the car. There's some things that occurred that just weren't, in the words of Mr. Sanders, it wasn't a perfect transaction. And actually, in the words of Mr. Sanders, the December 28th transaction was certainly not a perfect transaction, at least for the state's part. You're here to decide the facts and whether or not it's sufficient enough for a conviction of my client, Mr. Weil. The thing that I'm going to remind you after you've heard this testimony all day today is the great weight of the state against my client. You heard Mr. Sanders say that he was not a high-end person. As a matter of fact, after the last transaction, they decided that was all they wanted to have. I believe there has been a reasonable doubt established for at least the first and the last, and I would submit all three. It is your job to think of each one of these incidents, each one of these dates, separate. You don't have to convict on all three if you don't have the evidence for all three. With that, I say reasonable doubt has been established, and I thank you for your deliberation.
All right, thank you. Mr. Collins?
I'll start with a few things that Mr. Borger said in his closing. And the first is that there is absolutely no proof at all that Joy Debo was lying in her testimony. If you remember, he repeatedly questioned her again and again and again and again, hoping that she would change her testimony or hoping that she would change her story. And she didn't do that. She didn't change it at all. And the testimony was she knew the defendant prior to December 5th because she had gone to his house with a friend of hers that was a mutual friend with the defendant, and she had bought meth from him before that. And Mr. Borger is asking you to speculate about knowing him even before that because he had a crush on her daughter. Well, first, you're not allowed to speculate. Secondly, maybe the daughter came home in high school and said, hey, Stephen Will has a crush on me. We don't know. It's not relevant. It doesn't make any difference. Joy Debo bought dope off of the defendant prior to December 5th, and on the 5th, the 8th, and the 28th, she bought dope off of him again. That's what's relevant. That's what's important. Investigator Sanders' testimony was not exactly as Mr. Borger said either. He said only that the third transaction was not perfect. And why was it not perfect? Because it got dark. They don't like to do the deals in the dark because the cameras don't show up as well. You know, you can't see as well, obviously. That's common sense. Now, one of your main jobs as the jury is to weigh the credibility of the witnesses. And to do this, you apply the testful truthfulness that you apply in your everyday lives, just like we talked about in jury voir dire. You look at the person's appearance on the stand, their manner of testifying, the reasonableness of their testimony, the witness's opportunity to see, hear, and know the things that they are testifying about. You look at their accuracy of memory, their frankness, their interest and bias, and then you decide, with all of the facts and circumstances surrounding their testimony, you decide who to believe. And let's apply this to the witnesses that you heard from today. You had 2 BCI chemists. They were declared experts in that they have specialized schooling and training, and they gave their expert opinion about their findings. And their findings are recorded on BCI reports, and you will have them. They are labeled States Exhibits 1, 21, and 46. And each report lists the result of the test, showing that the item was methamphetamine, and it also lists the weight. So you don't have to guess about that. It says it on there what the weight was. Next, you heard from Joy Debo, who said that she worked as a CI for Investigator Sanders and Bowen, and that she purchased illegal narcotics from various people. She arranged these purchases using her cell phone and text messages that you will be able to review in the jury room. Joy saw the defendant each time he walked up to the passenger side window of the vehicle and handed her methamphetamine, and she handed him the recorded buy money. Now, the defense wants you to ignore the testimony, made a big deal about the fact that she was getting paid for her work and things like that. Well, we would all expect to get paid to work. We don't go to work for free. So, of course she got paid. She's no interest or bias. She was open in her testimony. She couldn't remember something. She simply said, I don't remember. I don't recall that. She was in the best position to see and hear what happened on December 5th, December 8th, and December 28th. She literally is the one doing the hand-to-hand transaction. You also heard from Steve Debo. Again, he was open with you about the crimes that he committed and about his addiction. He was in the best position to see and hear what took place during each deal. So they're in a little vehicle. You can see that in the videos. It's a small vehicle. He's driving, she's in the passenger seat, and there's about this much room between them. He's in a very good position to see who comes to the window and hands something in. Next, you heard from Investigator Sanders and Bowen. Investigator Sanders has over 40 years of experience, mainly focused on covert drug operations. Again, he kept detailed notes of his work, kept track of audio and video recordings of the buys, kept track of the buy money, collected all the evidence available, and has relayed all that to you today in an open manner. He was in the best position to see and hear what was happening in each of the deals, because remember the testimony. Investigators Bowen and Sander are literally watching as it happens. They're watching it live. That recorder that they put in the vehicle, if you remember their testimony, they can watch and hear everything that's taking place as it's happening. Investigator Sanders has no bias or interest. He's simply doing his job. And finally, you have heard from Investigator Bowen, who has over 30 years of experience, again, focused on covert drug operations. Again, Investigator Bowen kept detailed notes of his work, kept track of audio and video recordings of the buys, kept track of buy money, collected all the evidence available, and again, has relayed all of that to you. He was in the best position to see and hear what was happening in each deal, because I just told you, they're watching it live as it's happening. Investigator Bowen has no interest or bias in this case. Now, there's been a little bit of insinuation during the questioning that maybe Joy might have had this in her purse, this dope in her purse, or they weren't searched thoroughly or something like that. But let's use our reason and common sense. It's really far-fetched. So each time Joy and Steve did a deal, they somehow managed to hide meth somewhere and magically get it and put it on the on the orange thing because the testimony was that the camera faced the meth on the orange vest in the middle of the vehicle from the time they got it till the time that they met back up with Chris and Randy. So they just randomly drive to a gas station. The defendant walks up to their vehicle for no reason at all. Joy counts out money because you can see that on the video. You can see her with the money in her hand. So she just hands this defendant money for no reason. They had the dope the whole time. That absolutely makes zero sense. That flies in the face of common sense. Then they drive to his house on 2 occasions and hand him money and a pack of cigarettes, just randomly for no reason. No, they drove to his house and handed him money and a pack of cigarettes because he was selling the meth. And again, you have the text messages setting up the deals. Now, also remember that during the testimony and during the videos that you watched, as soon as they get the meth and the defendant walks away from the vehicle, the camera is immediately placed on that meth. It's laid down in the middle in the console and the camera is placed on it so that Chris and Randy can see it the entire time. From the moment they get it to the moment they get back to Randy and Chris, that they can see it. Also, the question was asked of Joy during her testimony, how did she know, or how did you know it was Steve Weil that you were texting? And here's this circumstantial evidence that we talked about this morning with the snow. So Joy would send a text to someone that she knew was Steve Weil at a phone number that Steve Weil provided to her, and then Steve Weil would show up and give meth. So that's a pretty good, that's really strong circumstantial evidence that that's who she's texting. If that person shows up with the amount of meth that you've just ordered, that's pretty strong circumstantial evidence. They also have indicated that it was Joy's idea to meet in the Marathon gas station, and it was Joy's idea to meet there because it was in the vicinity of a school zone, or it was Joy's idea to meet at his house and things of that nature. But that is not the evidence. And when you look at the text messages on the phones, it'll be very clear that is not the evidence. Look at State's Exhibits 7, 8, and 9, I believe, are the text messages for at the Marathon gas station. The defendant says, I can meet you at the gas station or at this school in Morristown. That's his words, not Joy's words. And you will have these text messages to look at in the jury room. He decided where to meet for these buys. He told her, you're going to have to come to my house for this because I don't have a vehicle. Hey, just run by my house and get this. At the third deal, she wanted him to meet her in Morristown. He said, nope, I don't have a vehicle. You'll have to come by my house. He decided where to meet, not Joy. Another thing that I hope that you picked up on is that Investigator Sanders told you that either he or Investigator Bowen, they turn on the camera that records that they can watch the live feed on, and they put it in the vehicle, and they don't tell Joy and Steve or any other CI how to turn it off. So the video starts from the second that Investigator Sanders or Investigator Bowen or Sanders or Bowen put it in the vehicle. The camera starts, then they turn it on, they place it in the vehicle, and it runs until they take it out and shut it off. And you've heard that, some of these drives took 25, 30 minutes. So that's a video that is 30 minutes long for about 2 minutes of deal. But the entire time, either Chris or Randy are watching this on the screen. They're watching everything that's happening. They know exactly what's happening. And there's no time to shut the camera off and sneak dope in or sneak dope out because they don't know how to shut the camera off. They just don't. Now look at the elements of the crimes alleged and the evidence and testimony that proves each of these crimes. Counts 1 and 2 are the cruiser deal. The deal when the sheriff's office gets behind the CIs and they have to turn off to get away from them. Aggravated trafficking of methamphetamine in the vicinity of a school and aggravated possession of methamphetamine. Counts 1 and 2 are related to this Marathon gas station in Morristown on December 5th of 22. And again, text messages to review how the deal was arranged through 6 through 17, States Exhibits 6 through 17. When Steve and Joy arrived at Marathon, Will walks up to the truck, went to the passenger side. Will handed Joy the bag of meth, weighing 6.9 grams, and Joy handed Will the recorded buy money, $120. And you can review the details of this buy on States Exhibit 3, which is their surveillance report. States Exhibit 18 was the video that was played, and States Exhibit 19 is a picture. And the picture is of the defendant. You can clearly see him, and the testimony was that Investigator Bowen pulled that picture out of the video. When he's standing at the car window, that's when Investigator Bowen took the picture. States Exhibit 19. You can see the defendant standing at the car window, Joy's leg. This is the car window, or the truck window right here at the Marathon gas station, and this is directly from the video of the buy. Now, the direct evidence is that Will sold meth to Joy and Steve Debo. And now, obviously, when a person is selling meth, he is possessing meth. Now, next you must decide for count 1 and count 2 if this was bulk amount of meth. And it's really an easy finding because we provide you with the BCI reports, and the jury instructions clearly say what bulk amount is. So you look at States Exhibit 1, which is the BCI report, and the weight of the meth is right here, and it's on each of these reports for each buy. You look at States Exhibit 1, and you'll see that it weighs 6.9 grams. According to the jury instructions on pages 7 or 8, right around in there, bulk amount of meth is 3 grams. So did this weigh at least 3 grams? Yes, it did. So it was greater than bulk amount. Then you have to decide if it was in a school zone. Well, you have the map. Now, there was a little talk about this. You have the stipulation that Wright Local School is a school, and you have the map which shows the distance from the Marathon gas station to the school as 825 feet, so obviously less than 1,000 feet, which is what's required by the law to be in a school zone. Now, there was a lot of talk about, well, this is as the crow flies, and this is in the vicinity, and does it include the property line? Well, you guys look at the jury instructions on page 8 and 9, and you'll see it does. It doesn't say that it has to be down this road and down this road and up this road, and it doesn't say anything like that. From one property line to the next is in the vicinity of a school zone. That's what the jury instructions say. So you'll find that on pages... You will find that on pages 8 and 9 of the jury instructions. That whole section right there deals with the school zone. This is clearly within 1,000 feet of a school zone. The state has proven each element of counts 1 and 2 beyond a reasonable doubt with the additional findings that it was greater than bulk amount and in a school zone. Next are counts 3 and 4, and this is the first deal that took place at Wheel's house when the truck breaks down. Again, you'll have the text messages to review, States Exhibits 26 through 30, in which the deal was arranged. Steve Debo drove Joy to the house, and then Joy makes a phone call, and a female answers, and she says, "Hey, is Steve there?" Remember this in the video? And a guy gets on, "This is Steve," and she says, "Hey, would you come out?" And who comes out? This defendant, Steve Weil. And when he comes out, he walks up to the passenger side of the vehicle. He hands Joy a bag of meth. The meth was sent off and weighed 7.38 grams, and Joy hands Will the $120 in recorded buy money. Now, the defense said it's notable that he had just moved into this house the day before. Well, again, he decided where the deal was to take place, and what is noticeable about just moving into the house the day before is that when Joy and Steve pull up, he asked Joy if she has scales. "I can't find my scales because we just moved in. Could you take this home and weigh this and let me know?" That's the discussion. Yeah, it's important that he moved in. It's important because he couldn't find his scales to weigh the dope. Again, you have State's Exhibit 23, which is a surveillance report to detail exactly what took place as it happened. You have the video in State's Exhibit 31. And again, you have 2 pictures of the defendant at the deal. So again, they watched the video and they were able to pull 2 still shots of the defendant standing outside of the vehicle. Right here, State's Exhibit 32 and 33. Again, you have to make the additional finding that the amount of meth was equal to or exceeding bulk amount, and you have the BCI report, State's Exhibit 21, which shows that it's 7.38 grams, so obviously greater than bulk amount. Ladies and gentlemen, again, the state has proven beyond a reasonable doubt that Stephen Weil trafficked in meth in an amount equal to or exceeding bulk, and that the deal occurred at his home. And then finally, count 5 is the final deal at Weil's home on December 28th. This is the deal where he asks her to bring a pack of cigarettes to him in the text messages, and they get there. You have the text messages, State's Exhibits 37 through 42. You have the surveillance report, State's Exhibit 36. And again, in the video, they pull up to the house. The defendant comes out. He hands Joy the meth. She hands him the money. And then she digs around in the car for a minute, finds the pack of cigarettes, hands that to him as well, and then he leaves. And you have, again, a picture of the defendant, State's Exhibit 44, which is a picture from the video. Again, the state has proven beyond a reasonable doubt that Stephen Weil sold meth, and he is guilty of count 5. Now, finally, you decide the forfeiture specification. Did he use his property to further his crimes? Well, the answer to that is simply yes. The certified copy of the deed, which is State's Exhibit 34, shows that the defendant owns the property at 5005 State Route 138 in Highland County. Both deals on December 8th and the 28th took place at his home at his request. Stephen Weil used his property in the commission of his crimes, and as such, the property is subject to forfeiture. Now, the state must prove each and every element of the crime is charged beyond a reasonable doubt. And the defense keeps talking about the great weight of the state. Well, it almost seems like beyond a reasonable doubt is impossible, but it's really just not. It's doubt based on reason and common sense, and it's things that you decide in your everyday lives. You can equate it to maybe buying a car. You shop around, you collect evidence. You want a red SUV, and you find one, the odometer says 50,000 miles on. The payments will only be $400 a month. Your budget allows for a payment of $450 a month. This is everything that you want in a vehicle. All the evidence points to you buying the car, and of course you decide to buy the car. Now, there is some remote possible doubt that this isn't the perfect car for you, but reasonable doubt, doubt based on reason and common sense, which is what the definition of reasonable doubt is, it's been overcome, and of course you buy the car. It's not your job to look for reasonable doubt. If it had existed, it would have presented itself in this case. In this case, reasonable doubt, doubt based on reason and common sense, has been overcome, and the state has proven each element of the crime beyond a reasonable doubt. Ladies and gentlemen, because we've proven each element of the crime in this case is just not difficult. Investigators Sanders and Bowen have put the work in, and they've put the hours in, and I'm asking now that you simply review the overwhelming evidence, remember the testimony, use your common sense, and come to the only logical conclusion. And that is that this defendant is guilty of all counts charged. Thank you.
All right, thank you. Now, ladies and gentlemen, you've heard the closing arguments of counsel, which I'll remind you again are not evidence. I'm now going to instruct you on how to conduct your deliberations and prepare your verdicts once you've reached them. You must be uninfluenced by any consideration of sympathy or prejudice. It's your duty to carefully weigh all the evidence and decide all the disputed questions of fact, to apply the instructions of the court to your findings and to render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all the evidence and use your common sense and make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so that the state defendant will feel that their case was fairly and impartially tried. Now, during the course of the trial, the court's done or said anything you think is an indication of my view of the facts or the case in general, you're instructed to disregard that. Your initial conduct upon commencing deliberations is a matter of great importance. It's not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide that you may be, or you are, wrong. Consult with one another, considering each other's views, and deliberate with the objective of reaching an agreement, if you can do so, without disturbing your individual judgment. You must each decide the case for yourself, and you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change your opinion if you find that it's wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of the other jurors. Now, you may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine punishment is placed by law upon the court. Now, when you go to the jury room, your first function will be to select one of your number as a foreperson. And that person that you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. Foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. Now, as I've indicated, I'll place in your possession the exhibits and the verdict forms, and the foreperson will retain those records, including the verdict form, and return them to the courtroom. You won't have the DVDs to play because we can't give you any kind of electronic device in the jury room. But if you do want to watch those again, you can tell us, and we'll bring you back to the courtroom to do that. Now, until your verdicts are announced in open court, you're not to disclose to anyone else the status of your deliberations or the nature of your verdicts. Now, this being a criminal case, before it can be said that you reach a verdict, it's necessary for all 12, and again I'll repeat, all 12 of you to agree upon a verdict as to all counts. Now, you will have with you in the jury room, in addition to the exhibits that's been admitted and a copy of these instructions, 6 verdict forms. And I'll show you an example here. And again, I have to make a couple of corrections. But you can see from there, this has the name and the case number on it and the count. And in this count, 1 is aggravated trafficking of methamphetamine. And then it reads that we, the jury, having been duly impaneled and sworn, find the defendant, Stephen Charles Weil. Then there's a blank space where you insert guilty or not guilty in writing, in ink, of aggravated trafficking as he stands charged in count 1 of the indictment. And then this verdict form has 2 additional findings if the verdict is guilty. First one is to find that the amount of methamphetamine involved was or was not, and you'll strike out the one that's not applicable or circle it so that when we read the verdict form we can tell what your finding is. Equal to or exceeding bulk amount, but less than 5 times bulk amount. And then the second additional finding is further find the offense was or was not committed in the vicinity of the school. Then count 2 reads aggravated possession of methamphetamine, and that says that reads the same way, except it says of aggravated possession of methamphetamine as he stands charged in count 2 of the indictment. And again, that has the additional finding of whether or not the amount involved was or was not equal to or exceeding bulk amount. Count 3 is aggravated trafficking methamphetamine. It reads the same as the first count, except that there's only 1 additional finding, which would be whether or not the amount involved was or was not equal to or exceeding bulk, but less than 5 times bulk. Count 4 is aggravated possession. It's the same as verdict form. Basically, it's count 2, just a different count. Also has the same additional finding. Count 5 is the aggravated trafficking, and it's the same as count 3. You have the additional finding of whether or not, no, this one does not have additional finding. Yeah, so that one will be just straight guilty or not guilty. And then count 6, the forfeiture, reads that we, the jury, having been duly impaneled and sworn, find the real estate listed in count 6 of the indictment, and then you'll insert in ink either is or is not subject to forfeiture due to its being used to commit, to facilitate, or to aid in the commission of the offense charged in counts 3 and or 5 of which we have found the defendant guilty. Because remember, if you don't find guilty of either 3 or 5, then you have to find that the property is not subject to forfeiture. You only consider that if you have a guilty verdict on 3 or 5. Now, once you've reached your verdict, each of you will sign your name and ink on the verdict form. And again, all 12 have to agree. And that is your signature on the verdict form. is your statement that is your verdict and that you concur in. Now, during the deliberations, which will take place in the jury room, you'll be in charge of the bailiff and bailiffs, and they'll ensure that your deliberations aren't interrupted and will be your means of communication with the court. And I didn't say this earlier, but you can't have any cell phones or any type of electronic devices, iPads, etc. And so when you go back into the room, you just put your phone there on the windowsill. The bailiff will collect them in bags and then return them to you at the conclusion of your deliberations. Because you're not permitted to have any means of communicating outside or doing any research using the internet or anything of that nature. So that's why we have to do that. If you have a question or a request, you write it down, knock on the door, and give it to the bailiff. And then he will give it to me, and then after I've consulted with the attorneys, I'll determine the response and return it to you in writing. Now, I can't promise you I can give you what you asked for. I can only promise you I'll consider it. And I'll give you an example. If you ask a question, all right, what color was the car that was allegedly involved in this incident? Well, I can't answer that. If there was any testimony about it, it's in the record, and the 12 of you will decide that. If there's none, I can't give it to you. So you can't ask me to give you evidence that's not in the record. And so I'll just have to respond in that fashion. These are long instructions, they're 28, almost 29 pages. And so it may be difficult to read. It's difficult for lawyers sometimes to read. So if you have a question about the law, I will probably just say, okay, you will find this on page whatever of the instructions so that you can look at it there and find it. All right, now, and again, you can't ask the bailiffs any questions. The only thing you do is give them a written request and they can communicate it to me. They're not allowed to answer any questions or discuss the case with you in any way. Now, once you've reached verdicts on all counts, then you'll knock on the door and inform the bailiff. Then he'll return and let us know. We'll reassemble, and then once everyone's reassembled, you'll be returned into the courtroom for the reading of your verdicts. Now, I want to thank all of you for your patience. This case has moved along fairly quickly. We've attempted not to waste your time. I think the attorney's done a good job of making sure that didn't happen and presented their cases expeditiously, but with a full opportunity to present it fully. Is there anything further from counsel?
No, Your Honor.
All right. Now, at this time, Mrs. Winters and Ms. Donaldson, as the alternates, you're not going to be deliberating. And so I'm going to allow you to leave with a couple of instructions. First of all, you'll need to provide a cell phone number to the bailiff, and don't leave the county. And the reason for that is this. In the event that during deliberation something happens, that one of the jurors has to be excused for whatever reason, then we will call you. We will call Ms. Winters first and then Ms. Donaldson to come back. So that's why we need you to stay, in the county. And then also, the instructions I've given you are still in force. You're not to discuss the case in any way, to read anything about it, to talk to anyone about it, do any research about it. Everything that I gave you, the instructions this morning, you're still to observe. When we do have a verdict, then the bailiff will call you and inform you of that. And at that time, you'll be released from your obligation. Your service will be complete. And you may, if you wish, talk about it. You don't have to, but you'll be free to do that. So at this time, if the two of you would just go around this way, and Mr. Hodgson will take care of your vouchers, and you'll give your phone numbers to the bailiff here. All right, and then again, ladies and gentlemen, the jury, will leave your cell phones on the windowsill. I've got to make some editorial changes here before I send everything back, but the bailiff will bring you the evidence and these instructions and verdict forms in just a few minutes. But you go ahead and proceed with your election of a foreperson and deliberation. Thank you. seated, everybody. I'm going to stand because my legs are tired, or crampy. All right, you said you had some additional
Just a few
corrections?
things. Page 1 in the caption, the wrong version of Stephen.
Oh, yes, okay, thank you.
Page 24, third line from the top, the dates are incorrect. It says December.
Wait, Ken. Page 24.
24, third line from the top, the dates, it says December 5.
Oh, okay, yeah, it should be 8 and 28, all right, thank you.
Of 22, not 23.
Correct, yeah. And then also down there, real estate was not in there. I read it, but I stated it, but it wasn't there.
And then the other ones, I think you caught as you were reading them, but on page 27, count 1, it says vicinity of a juvenile should be school.
Yeah, that's true.
And then
I read it that way.
page 28, count 5, the additional finding should not be there.
Page 28 counts what?
Count 5 on page
Yeah,
28.
no, it's, yeah. I
That's
did
all.
not read that, yeah. All right, and I found that on the verdict forms too, and I also found that count 2, I've got to change possession and change 3 to 2. Yeah. And then count 4, I got to do, I was cutting and pasting and then count 5, have to strike out the bulk. All right, anything else? Anything else? No. All right, I'll go make those changes and be back in just a couple minutes, and I'll give you corrected versions.
Please rise.
All right, the jury has informed the bailiff that they have a verdict, so Mr. Strain, if you'll bring the jury in with a verdict, please.
Yes, Your Honor.
Tell them to leave the evidence in the jury room and you can pick it up instead of bringing that in. This is the, that's the, go ahead and see. All right, let's see, Mr. Heiser, are you the foreperson? Yes. I have the verdict forms. Have you read the verdict on all 6 counts? We have. All right, if you would hand those to the clerk, please. All right. Mr. Johnson, if you would read the verdict forms, please.
Court of Common Pleas, Highland County, Ohio, State of Ohio versus Stephen Charles Weil. Case number 23-CR-110, verdict, count 1, aggravated trafficking in methamphetamine, Ohio Revised Code 2925.03A1. We, the jury, having been duly impaneled and sworn, find the defendant, Stephen Charles Weil, guilty of aggravated trafficking in drugs as he stands charged in count 1 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount but less than 5 times bulk amount. We further find that the offense was committed in the vicinity of a school. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Stephen Charles Weil. Case number 23-CR-110, verdict, count 2, aggravated possession of methamphetamine, Ohio Revised Code 2925.03A1. We, the jury, having been duly impaneled and sworn, find the defendant, Stephen Charles Weil, guilty of aggravated possession of methamphetamine as he stands charged in count 2 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount but less than 5 times bulk amount. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Stephen Charles Weil. Case number 23-CR-110. Verdict, count 3, aggravated trafficking in methamphetamine, Ohio Revised Code number 2925.03A1. We, the jury, having been duly impaneled and sworn, find the defendant, Stephen Charles Weil, guilty of aggravated trafficking in methamphetamine as he stands charged in count 3 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount but less than 5 times bulk amount. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Stephen Charles Weil. Case number 23-CR-110. Verdict, count 4, aggravated possession of methamphetamine. Revised Code 2925.11. We, the jury, having been duly impaneled and sworn, find the defendant, Stephen Charles Weil, guilty of aggravated possession of methamphetamine, as he stands charged in count 4 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Stephen Charles Weil, case number 23 CR 110, verdict, count 5, aggravated trafficking in methamphetamine, Ohio Revised Code 2925.03A1. We, the jury, having been duly impaneled and sworn, find the defendant, Stephen Charles Weil, guilty of aggravated trafficking in methamphetamine as he stands charged in count 5 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Stephen Charles Weil, case number 23 CR 110, verdict, count 6, forfeiture. We, the jury, having been duly impaneled and sworn, find that the real estate listed in count 6 of the indictment is subject to forfeiture due to its being used to commit, to facilitate, or to aid in the commission of the offense charged in counts 3 and or 5 of the indictment, of which we have found the defendant guilty.
All right, ladies and gentlemen, the court will note that all 12 have signed each of the verdict forms, and I'll ask if these verdicts that have been read are the verdicts of each and every one of the 12 of you. Everybody agrees? All right? You want the jury poll?
No, Your Honor.
All right. All right, ladies and gentlemen, then the court will accept your verdicts and findings of guilty according to your findings in counts 1 through 5, and that the real estate is subject to forfeiture. This will complete your service today. You're now released from your obligations that I gave you. You can talk about the case if you wish. You don't have to. And you will be exempt from being called for the rest of this term, since you got lucky and got called the first week. So you're good for the rest of the year and another year after that. Should you get drawn, our system, we have a system now, which of course we see what happened here. That thing came on its own. I wasn't anywhere near it, but if you do happen to get drawn again this quarter or next year, call us and let us know when you served, and we'll make sure that you're excused. That's only happened once in the last 15 years, but it does happen. So with that, then, if you will go downstairs, Mr. Hodgson can provide any work excuses and your pay vouchers. And also you can pick up your phones there before you leave. And again, thank all of you for your service. And the council, if you'll remain, I need to go to retrieve something in the chambers. I'll be right out. All right, we're back on record, case 23 CR 110. Defendant's been found guilty of all 5 counts charged. I believe count 1 is a mandatory sentence required. Is that correct, Ms. Collins?
It is.
Yeah. So And the court's familiar with Mr. Weil since he was in drug court before he was indicted on this charge. And so I'm going to go ahead and proceed with sentencing. Now, the court finds that counts 1 and 2 and counts 3 and 4 must merge as a matter of law since they are the same offense and same evidence, and so the state would need to elect which one to be, they would like to be sentenced on, and that would be
1 and 3.
1 and 3? Okay. All right. Anything from the state regarding sentencing?
We would ask that, obviously, this is count, as the court said, count 2 is a mandatory term of incarceration. We would know that these are 3 separate buys, not related to one another, other than all done by the same defendant. We would also note the defendant's actions prior to being brought to trial. There was a warrant out for his arrest for quite some time in this case. We were initially scheduled to try this case in August, and then we were scheduled a second time in September, and we weren't able to locate him from the end of September or mid-September until sometime in March when he was, or late February, early March when he was finally arrested on that warrant and brought before the court. I would also note that as Investigator Randy Sanders testified to, this is a significant amount of methamphetamine for Highland County. He isn't a major drug offender as far as, selling whole ounces and up to pounds, but 8 balls or 2 8-balls at a time in Highland County is a significant amount of meth for each deal. And then finally, he chose the area and actually offered the school as an option to do the first deal at. So we would note that as well and ask the court to sentence the defendant to a substantial term of incarceration. Thank you.
All right, Mr. Borger.
With respect to sentencing, Your Honor, a couple things I'd like you to know. Clearly, you know that he was a part of the drug court, and I think that he was doing very well at that point. This indictment triggered something in him that obviously did not cause him to do some of the things that I know and that he knows that he should have done. He did go to Indiana. He was working. He was working as a W-2 job, and at that point he was paying child support, and I am certain that's how he was found to be where he was. Clearly, he offers no real reason as to why, or won't get any good reason as to why he left. He knows that it was wrong, but he certainly has shown an ability through the drug court to be able to follow the terms and conditions and to stay clean and to stay productive. And so he wants you to take that into consideration when you're given the sentence here.
Mr. Will, is there anything you'd like to say?
I was doing good, doing everything I was supposed to do when these came out. Even then, I was going to court. I turned myself in when they initially came out, bonded out, was still doing what I want, was trying to do. I did relapse, so I called my dad. When that happened, didn't know what else to do. He come and got me, went and stayed with him. That's when I ended up, staying there and missing court, and I guess it got out of hand from there. So these are serious charges, I know that. So I was trying to do everything I could, and I felt like I was making good headway, and then, all this kind of hit me, and it was very overwhelming, and I just, didn't know what to do with myself. Sorry for that, but, I am, still feel I am able to do good, and I did not relapse, and I was, still taking care of stuff, even though I missed court. That's it, sir.
Where were you staying with your dad?
At Madison, Indiana.
Okay. And when did he die?
Huh?
You say he died?
No.
Oh, I thought you said you lost your dad.
No, I said I called him and he...
Called him, I'm sorry, I misunderstood.
Yeah, because I relapsed, I called him and he...
Okay, I've got you.
And he come and pick me up and, come stay with him.
All right, anything else you'd like to say? All right. Well, first of all, you were in the drug court in case number 22 CR 129. And, you were doing well, and I even told you when you got indicted on this case that, because you bonded out when you were charged, I believe, before you were even indicted, if I'm not, well, I may be wrong on that. But in any event, you did bond out. And, I explained to you that since this happened, allegedly happened prior to your conviction in the other case and being placed in drug court, that it would not affect that, if you had to serve a sentence, which of course there's a mandatory term here, that, we can toll time in drug court, and then once you've completed your sentence, come back. And I've actually got one lady that's done that already, actually two, a young man and a young woman, both are doing well. They served their time, came back. We've got another guy who ended up with, out of Scioto County with a similar type of situation, mandatory time, and he's, I think he's doing 2 years, and he's due to get out. He's going to come back to drug court. And I told you that. And told you if you kept doing things right, that, you could hold your place in drug court after you got done with a sentence if you got convicted. And so, you were given every opportunity. And so it's not that you just skipped out here in this case, but you skipped out in drug court too. You quit. And you were indicted on this case on June the 6th. You didn't take off until September the 12th, I believe was the date. Yeah, September the 12th, and it was over 5 months before you were caught. And where were you arrested, by the way?
At work in Indiana.
At work in Indiana. So, it wasn't like you came and turned yourself in. And so, taking all those things into consideration, plus the fact that I believe you have at least 4 or 5 prior felony convictions and 2 numbers, is that right?
I think I've only been in prison one time. So.
Oh, okay, only one time, so all those were consolidated then. I know you had 1 in Montgomery County, and I believe you have 4 from here now, plus these. So based upon all that, it is the order and judgment of the court as to count 1 that you be sentenced to a mandatory term of 4 years, and under the law, that will be served first, and the Adult Parole Authority, or I'm sorry, the Department of Rehabilitation and Corrections could choose to extend that to an additional 2 years or 6 years total if they decide to do that under the Reagan-Tokes law. But the first 4 is mandatory. On count 3, you're sentenced to a term of 24 months, and on count 5, you're sentenced to a term of 12 months. Those are each ordered to run consecutively to each other, so that'd be a total of actually 7 years minimum, and possibly 9 years maximum if the DRC extends your mandatory time, as they have the right to do. With regard to the credit for time served, according to this, there's only 1 day on this case because all the time you have has been credited to the 22 CR 129 case because you were arrested on the cases on that. That was the first case, and so there's 104 days credit on that, but there's only 1 day credit here, June the 7th, and then you were bonded out on June the 8th. Now, upon completion of your prison term, it is mandatory to be placed on, as to count 1, on post-release control. And so I believe that's 18 months minimum, 3-year maximum, correct?
That's correct.
All right. So you'll be at least 18 months and possibly as much as 3 years under post-release control supervision as determined by the Adult Parole Authority. And if during that period of time they determine that you have failed to comply with those conditions, they can sanction you by returning you to prison to make you serve an additional period of 9 months for any single violation, up to a maximum of half of the prison term for all violations. However, if you should be convicted of a new felony, then in addition, whatever sentence the judge in the new case could impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater, and if that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, for which judgment grant execution order. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. And the community service that you could do to work it off would only be after you get out of prison, not while you're in prison. And what's the total amount of restitution for counts 1, 3, and 5?
240, 290.
$290 is ordered to be paid as restitution as a substantive order to the Highland County Task Force, and that will be payable through the Highland County Victim Witness Escrow Restitution Escrow Account. You'll pay any fees associated for that. That is a substantive order. It cannot be discharged by bankruptcy nor by service of your term. And if you don't pay it, that can be enforced by other legal means under the law. Now, the reason for those consecutive sentences is because, as I indicated, you've got, well, first of all, you have an extensive criminal history, and so it's necessary to protect the public from further crime for you to be sentenced to a longer period of time. The court will find that these offenses were committed as a series of offenses over a period of about 3.5 weeks, and one single prison term would not adequately reflect the seriousness of their conduct, and the sentences that are being imposed are not disproportionate to the harm that is caused. Now, the court also imposes a mandatory fine on count 1 of $7,500, and I believe there's a mandatory fine on count 3, isn't there, $5,000?
Yes, that's correct.
Right. And that is imposed. They're not a mandatory in 4, though, on a 5, is there?
Right.
All right, so I'm just going to impose the 2 mandatories. And so those must be paid through the clerk of courts. To the credit and of the prosecutor submitted entry as to identifying where those funds go, I'll assign that. Just put that in the sentencing entry if you would. Now, as to counts 3 and 5, post-release control is optional for up to 2 years, but again, it's mandatory. You're going to be on under count 1 for 18 months to 3 years. All right, now, you've been convicted of the offenses. Oh, it's also ordered that the real estate listed in count 6 be forfeited, and that'll be subject to, forfeited to, how do you want to do that, Ms. Collins? Is it going to be forfeited to the commissioners to be sold, or?
Yes.
All right. So it'll be forfeited to the Board of Commissioners of Highland County for the purpose of being sold, and the proceeds of the property then distributed also according to the formula that the prosecutor includes in the sentencing entry. Now, Mr. Weil, you have a right to appeal the verdict and the sentences in this case. You have a right to have all the papers that are necessary to do that, including all the files, plus the recordings, transcripts of the recordings that have occurred in this case. If you do not have the money to pay for that, they will be provided to you at no cost. You have a right to have an attorney to represent you in that appeal, and if you do not have the money to hire one, the court will appoint one for you. If you intend to appeal, you'll need to fill out one of those financial disclosure forms before you're conveyed to the Correction Reception Center. If you do wish to appeal, your written notice of appeal has to be filed with the clerk of courts and the trial court, as well as the appellate court, the 4th District, within 30 days of your sentencing entry being filed, which will be tomorrow. Now, I don't know whether you would have any intent to prosecute any appeal, Mr. Borger. I would ask that you at least, if he wishes to appeal, file the notice of appeal to protect his rights, and then inform the court that it's a limited appearance only if the decision is you're not going to handle the appeal. If you're going to handle the appeal, that's fine.
Yes, Your Honor.
And then at that time, also indicate whether the defendant wishes or feels that he needs to have supporting counsel, in which case he'll have to provide that financial disclosure form. All right. Is there anything further on this case?
Not on this case.
All right. Now, Mr. Borger, I know you're not counsel of record in the other case, the drug court case, 22 CR 129, but one of the conditions, of course, is that he not commit any further crime, so the convictions in the new case obviously constitute that. Also, there was a notification filed back on February 20th alleging additional violations, including failing to report after August 31st of 23, and also on September 5 and 7. Rule 4, that he left the state of Ohio without permission, was residing in Indiana without written permission. Rule 7, that lists a number of times, looks like about 10, where he either tested positive for a controlled substance or failed to call in under the mandatory daily reporting condition, or after calling in failed to appear. And then Rule 13, that he had not attended outpatient services at what was then FRS is now TRC, as recommended after the positive test. And then on Rule 18, that on or about 9/8/23, he failed to appear in drug court. And I did notify him of that, and that I believe at that time, Mr. Wagner was appointed to represent him, but you're not in that case. I don't know if you intend to go ahead and enter appearance, and if you want to do that, we can deal with it either now, or I can deal with it later with Mr. Wagner, who is appointed. So,
Your Honor, I'll enter an oral appearance at this point and say that I will be representing him. He and I have discussed this, and he's going to admit to the violation.
all right. So, Mr. Weil, you do have a right to have a hearing in this matter, in which the state would have to present evidence through the probation officers, I'm sure, as to the alleged violations. That didn't include the conviction. This was the notice that was filed on February the 20th of this year after you were arrested. And you have a right to have your attorney cross-examine the witnesses and present any evidence on your own behalf, including witnesses you may call to testify. And in the event that you admit to the violations or you're found to have violated them by hearing, I can do one of three things. I can continue community control under the same conditions. I could continue with additional conditions. Or the third, the most serious, is that, and quite honestly the most likely, is that I'll revoke your community control and terminate you from drug court, and I could sentence you to anywhere between 9 and 36 months in increments provided by law, fine you $10,000. You understand the allegations against you?
Yes, sir.
You understand your rights to hearing?
Yes, sir.
All right, and you're okay with going forward here today according to what your attorney just said?
Yes, sir.
All right. You understand the consequences if you admit to the violations?
Yes, sir.
All right. Then do you admit to the allegations that were filed against you on February the 20th, as well as the additional violation that you've been convicted in this new case today?
I do.
All right. All right. Anything from the state regarding disposition in this case?
I would ask the court to revoke Mr. Wheel's community control and sentence him to a term of incarceration for this case.
Mr. Border?
Yeah, Mr. Weil has maintained that he actually did well on drug court. I understand what the inclination of the court is to do, but he has told me that he could thrive in that once he gets that opportunity again, which obviously is going to be some time. He's asking for that.
Is there anything you'd like to say, Mr. Weil?
Yes, sir.
All right. Well, like I said, I thought you were doing well, but, you know, one of the things we talked about in drug court is when you have adversity, how do you handle it? Do you deal with it and admit your issues and go forward, or do you do something else? You did something else. You stayed in for about, 2 more months, then you took off, and you were using. Now, relapse isn't an automatic revocation. In fact, probably 75% of the people who have graduated from drug court over the last 4 years have had at least one relapse. And so relapse is the one thing, but dealing drugs and then not taking responsibility for it. I mean, you had a right to have a trial in this matter. Quite honestly, I'm a little puzzled why you exercise that right, because in doing so, you exercise your right to be stupid. Because this case was a slam dunk. I mean, there's no doubt about it. They got you on the tape. They have your voice. They've got pictures of you from the recording. You're going to your house, your address. I mean, but you wanted to fight it, and that's fine. If you want to do that, that's fine. But again, what that tells me is, in terms of drug court, is you're not about getting sober and staying sober and rebuilding your life. You're about continuing to stay out of jail. And although these things happened beforehand, your conduct certainly shows that that wasn't your intent. I don't know what you thought you were doing by going over to Madison and living with your dad, I mean, you know, the law always finds you. You know, I know we see these TV shows, and about once in a million times, somebody takes off and hides out successfully for years. There was one guy, I think, just took off from Cleveland and just died in New England and been a fugitive for 40-some years. Well, that's the exception. For every one of those people, there's a million like you that get caught. And, you know, it's just done, you know. And again, it shows that drug court for you was just a means to stay out of prison. It wasn't serious. So it's the order of court that, the finding of the court that you violated the conditions, that you're not amenable to community control, and therefore you're terminated from drug court and your community control is terminated. It is the order of the court that you be sentenced to a term of 18 months, and you'll be given credit on that according to the sheriff. All the time since February 19th, then when your arrest has been added to it, that was 49 days. Prior to that, you had 55 days credit, so you'll get 104 days credit against that sentence. It is the order of the court that this sentence also be served consecutively to the sentence in the new case. Well, you know, let me back up. I have to strike from the record what I said. These offenses occurred before he was in drug court, so the conviction here is not a violation. So it's being based strictly, and I'll strike that from the record. That's my mistake. It's been a long day. It's just for the conditions in February 20, 2024. The court then will find that, again, your criminal history is such that that it's necessary to protect the public from you continuing to sell drugs, even though you're not the biggest drug dealer we've ever had. And, you know, big drug dealers require mid-level drug dealers, require little drug dealers, et cetera, et cetera. You know, it's a distribution system. You know, this is like GM is a big car dealer, but, you know, they have to sell cars through little dealers in smaller areas as well as in big areas. And so, you know, you were selling 7 ounces, which, as Officer Sanders said, and from my experience, I've found that to be true in the cases, is a pretty good amount for Highland County. And so it is, your criminal history is such that this sentence should be served consecutively as well. And again, they were different courses of conduct. One single sentence would not adequately reflect the seriousness of your offense, and the sentence imposed is not disproportionate to the seriousness of the crime. All the sentences in these cases, various counts being an intermediate sentence in the ranges provided by law. You're also ordered to pay the court cost in this case, which judge grant execution is ordered. And if you fail to do that, the clerk can collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your community control or your sentence, not while you're in prison, but once you get out, you can do community control in this county, be given credit for each hour you work. In an hourly rate set by the court, each hour you work will reduce your judgment by that amount until paid in full. There will be no license suspension in this case or no fine. All right, and you're remanded to custody on this case as well. All right, anything further from counsel?
No, Your Honor.
All right, thank you.
Please rise.